Okay. The Senate Judiciary Committee will come to order. The clerk will call the roll. Okay, thank you. The first bill, Senator Sproul, 1113. Senator Sproul, I understand you got it all fixed? Okay, Senator Sproul, 1113. This is a bill that has to go to finance if it passes. I believe that's what I'm told.
Mr. Chairman, members, good morning.
Good morning.
Since we met last, Mr. Chairman, members, we met with the committee, those who have a concern. I believe Charles is on the line, and the new version, a substitute, the change was made on line 26, says any person 18 years of age or older who communicate with threat, and what they put in writing. That was one thing, in writing.
Mr. Chairman,
Be in writing. Yes. Who's this?
Surville, I move the substitute.
Okay. It's been moved to. Let's hear the substitute first, then we'll move it. Go ahead. Explain it.
So the change, Mr. Chairman, is that on line 26 was the alpha threat. They put it in writing, and then to another to kill. Then also on line 27, if you go down to such threat with intent, then they put in intimidate a civilian population at large. There were the two changes that was made to the bill.
Okay, it's been moved and seconded to adopt the substitute. Any questions? All in favor, say aye. Aye. All opposed, no. Motion carries. Okay.
Yes.
Any questions of the patron? Okay. Anybody in the public would like to say anything about Senate Bill 1113, the substitute?
Mr. Chairman?
1113, yes.
Surville,
Senator Sherrill.
speaking of the bill, I don't have a question, but I just so we're clear, what we did to change the bill was the existing statutory scheme only provides for felony offenses if a threat is made in writing as opposed to verbally. My assumption is the reason for that framework is that verbal threats are basically he said, she said, and it appears to me that the prior intent was for verbal threats to be misdemeanors and written threats to be felonies. So if Senator Sproul wants a felony, that's why we added in writing, because this would have been the first verbal threat that could result in a felony. So that's basically what the change did. And I think that's a better way to handle it than what was proposed.
Okay. All right. Yeah. Okay. Senator Saslaw.
With the change, prior to him making those changes, you and I are in a bar, we get in an argument, and I say to you, well, if you say that again, I'm going to whip your butt. Under your original bill, would that have been a felony?
No.
No.
It says bodily injury.
Well, he's making so this has got to be in writing.
Yeah, he's changed it.
But he's making it verbal.
Mr. Chairman, Surville.
Senator Sherrill.
This specific change that Senator Sproul is proposing relates to threats to intimidate a civilian population at large, to influence the conduct or activities of government, or compel the emergency evacuation of a place. This has to do with somebody saying, I'm going to shoot up the school without threatening a specific person. I'm going to shoot up the police station without threatening a specific person. That's the idea, not something said in a bar. Or I guess it could be, but a verbal threat in a bar wouldn't count under this because it has to be in writing.
Yeah, this
Mr.
is
Chair.
Yeah, Senator Peterson.
Yeah, I also, it has to put the person under a reasonable apprehension of death or bodily injury. So it can't just be the type of talk that Saslaw and I have down at Kilroy's. It's actually got to be putting somebody in reasonable
That's a
apprehension.
restaurant in Northern Virginia. Yeah.
Where's Kilroy's? Okay.
It's in Northern Virginia restaurant.
Okay. Does everybody understand the bill? Is anybody from the public like to say anything one way or the other?
Mr. Chairman?
Yes, Senator Obenchain.
So, I mean, just put it in the legislative setting. I mean, if a member of the public appears at a committee and points their finger at us and says, you're going to rue the day that you pass this bill, Could that be prosecuted as a misdemeanor?
Anybody answer that? Steve Benjamin? Charles? I can't hear you.
We're probably going to rue the day we
Go.
passed a lot of stuff.
Okay, yeah, Steve?
The substitute requires that it be in writing.
Yeah, it's got to be in writing. You
Well,
can't-
Mr. Chair,
Yeah, Senator McClellan.
I mean, the language says it's a threat to do serious bodily injury, so I think just saying you're going to rue the day isn't specific enough.
I'm going to take you out
Put it in writing.
Put it in writing.
in writing.
Put it in writing and
We're going to take each of you out.
threaten serious bodily harm.
I mean, they could certainly mean it in the sense of, I'm going to see that you're defeated for a reelection, but it may be perceived as a threat.
Mr. Chairman?
Senator Serval.
Thanks. If you look at subsection B, first of all, subsection B, which is existing law, only applies to employees of schools, healthcare providers, and that's about it. I'm not aware of a statute that makes it a crime to orally threaten somebody with harm, except if it's over a telephone or maybe by email. Well, email is not orally, but over a telephone, I know there's a phone threat statute, but a face-to-face thing, I'm not aware of, I'm going to kick your butt being a...
When I move the substitute be reported.
Okay, it's been moved. Does the substitute be reported? Is there a second?
Go to finance, Mr. Chairman.
Yeah, I think I heard a second. It's been moved and seconded that the substitute to Senate Bill 1113 be reported and re-referred to finance. Are you ready to vote? All in favor of the motion, vote aye. All opposed, vote no.
Senator Norman, how do you wish to vote? Not there.
Ayes 9, noes 2. The bill is reported, substitutes reported and referred to finance. Senate Bill 113. Okay, thank you. Let's move on to Senator Reeves. Senate Bill 1465. Senate Bill 14.
1129 first, that was leftover business on the
1129.
honor guard stuff. I had an amendment to that, Senator Morrissey's amendment. Do you have that on there?
1129, what happened to that last week?
Did we get rid of it, or I thought we passed it?
It's on block 3.
Oh, I'm sorry, we don't have,
Okay, all right. Yeah, Senate Bill 1465, Senator Reeves. Okay, pay attention to Senator Reeves, 1465.
thank you, Mr. Chairman. This morning I have 1465 for the committee, and what this bill is designed to do is bring into compliance and give some enforcement tools to help conquer some of these illegal gray machines. And I'm sure you all have gotten my email about the charitable machines that are running rampant as well. So I've been trying to work and find out how we can kind of get rid of these things. As I've been going through this stuff, I found that there's an enforcement hole. And when you look at what ABC can do with regard to this, they're telling us that they can't do anything. I have a letter dated to Senator Howe and Senator Lucas from ABC saying they really just can't enforce, and the amount of times that they've tried where Commonwealth attorneys are just too busy or the cases just don't line up. So what this does is, these things are showing up in vape shops, strip malls, hotels, laundromats, everywhere. And in the email I sent you on another bill, they do look like casinos. But the real problem with these gray machines that are unregulated is they're not paying any taxes, and the state and the ABC can't enforce. And I'm happy to share the letter that ABC sent to Senator Lucas and Senator Howell for that. But what this bill does is it allows a civil cause of action. So the county attorney can come in when he finds them in his jurisdiction. He can go through the civil process, catch these guys, seize their machines. The bill provides for a fine of $25,000 per machine, which falls in line with what the governor's original intent was as well. So it's a pretty easy bill. I also have some speakers lined up to talk about it. Mr. Chairman, that's pretty much the bill.
Okay, any questions of the patron? Yeah, Senator Saslaw.
Yes, sir.
I would assume that this would take effect after the skill games are gone.
Well-
Let's suppose skill games were legal in Virginia.
Yes, sir.
Well, then your bill wouldn't apply to that, right?
If they're legal, it doesn't apply. These are still, Senator Saslaw, Mr. Chairman, there are still games out there that are just proliferating like roaches that aren't doing it the right way.
Right.
You know, it's a policy decision. Do we want them or we don't? Well, those people who are doing it legally, I'm not even worrying about those right now. I'm just trying to catch the ones that don't have any stickers, that are just churning and burning out there.
All right.
How many, Senator, how many are there? Anybody have any idea?
Mr. Chairman, I don't. And when you look at ABC, and you look at amount of collections that contribute to almost $45 million, $45.5 million for the legal ones. And the illegal ones, Mr. Chairman, I can't even, we don't even know. I mean, it's that rampant. We don't know how many machines are out there. I can go case by case of 1, 2, 3, 4, 5, at least 15 or 20 where ABC has gone after them, and the Commonwealth attorneys just don't want to enforce them. So what I'd like to do with this bill is give the counties the ability to go after them, which counties need revenue, and these folks weren't paying any taxes, so we can catch the illegal ones that don't want to try to comply so we can get the original tax money.
Okay, any questions of the patron?
Mr. Chairman.
Yeah, Senator
Boysko.
Boysko.
Thank you, Mr. Chair. Question for the patron. Would you be able to explain to us, one, how the enforcement mechanism is actually going to work? I see that we have it, saying that the Attorney General's office is going to be working through it, and then is it also the Commonwealth's attorneys would be enforcing it? And then you just said that the localities would somehow get revenue. Are you saying that would be the
So, Mr. Chairman, Senator Boysko, so right now, in place, the way the governor has it done up in the bill, we're not taking anything from preventing Commonwealth attorneys from prosecuting the cases. We're adding an additional way to go after these machines because the Commonwealth attorneys are too busy doing actual criminal cases, and when you look at their dockets, they just don't have the resources or the time to go after them. ABC has not been able to do it as well, so we're trying to give an enforcement arm to the localities where these things are running rampant. And I've talked to several commissioners of revenue who know where these places are. They'd like to go after them. They'd like to get those funds and get rid of these places.
All right, Senator
Chairman.
Sherrill.
Thank you, Mr. Chairman.
Mr. Chairman?
Senator Sherrill.
Mr. Chairman, first of all, I have a motion, but secondly, speaking of the bill, I think this bill has I'm fine with the intent of it, but what I don't like is it seems to have a mandatory minimum $25,000 civil fine in it, and I think it should be a civil penalty of up to $25,000, not a mandatory $25,000 fine for every machine you find. I could see some people potentially being confused about whether or not they were allowed to have it or not, or getting duped into it or something, and it doesn't seem to me that this really gives.
You have a line amendment?
Well, Mr. Chairman, I would say that I would make an amendment that on line 103 and 108, that it be a penalty of up to $25,000 per device instead of a civil penalty of $25,000. So I would add up to on line 103 and 108, and that'd be my motion.
Is there a second?
Mr. Chairman, before you vote on that, let me just read part of the letter from ABC. It says, as a secondary but equal enforcement mechanism, ABC is also pursuing civil action to penalize unlawful game operators. The goal of these efforts is to initiate the pursuit and collection of civil penalties authorized pursuant to the legislation of amounts no less than $25,000 and not to exceed $50,000. So that's what I had just put 25. I didn't know how high we wanted to go and spank these people, but if we were going to go higher, I would contend just make it 25 and not to exceed 50 then.
Mr. Chairman.
Mr. Chair.
Sirville.
All right, Senator Sherrill, go ahead.
Mr. Chairman, the problem with that is that this doesn't have a knowing element. It doesn't say it doesn't say person who knowingly blah, 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 blah. It just says anybody who does X pays $25,000 for every one of these machines that's found. And so that's just not fair. So I stand by my motion.
Mr. Chair.
Senator Peterson.
Yeah, summer of 2019, I was at something called Asian American Convenience Stores Association. They had their annual convention in Richmond, and the vendors of these gray machines were all over the place. All over the place. They were practically sponsoring. And you have thousands of people there that own convenience stores all over Virginia, most of whom are first-generation Americans. And, you know, it's very unclear whether these machines are legal, whether they're illegal, and a lot of them probably have them in their stores. And it's, you know, just like the vaccine, sometimes we're a little bit slow in getting things out there. And, you know, if you're going to assess a $25,000 fine against a guy who's living on a margin of $6,000 to $8,000 a month, that's a lot. So I would support Senator Servell's motion, although I understand Senator Reeves's point, and I do want to support the bill.
Okay. Somebody else, Senator McClellan or somebody? Boysko? Okay. We have a motion, it's been seconded, to have a line amendment to say up to $25,000. Is that right? Yes. All in favor of that line amendment say aye. Aye. All opposed, no. Motion carries. Well, okay, motion carries. Okay, does anybody from the public like to ask any questions?
Mr. Chair.
Yes, Senator Morrissey.
To the patron, first of all, Senator Reeves, when you speak, if you'll just back up a couple of inches from it. You may have said this, but I didn't hear it. Do you have an estimate of the amount of revenue that is lost with these unregulated machines at unregulated locations?
Mr. Chairman, Senator Morrissey, I don't. I can only tell you what we have for the legal side, and my understanding is these things have proliferated so much so that we have no idea what we're talking about. Millions upon millions of dollars we're not getting in tax revenues. I've heard from at least 3 commissioners of revenue who know specific locations where they are just gaming halls. And there's no stickers on the devices. They're not regulated by ABC, VDAC. They're not charitable games, and they're not following under the lottery board either. So, or the Virginia Racing Commission. They're just illegal games. So, I have no idea.
Yeah, we have a motion to report the bill, the line amendment. Members of the public, is anybody from the public would like to say anything?
At this time, Mr. Chair, there are no hands raised to speak.
Okay. All right. Are you ready to vote? All right. All in favor of the motion to report the bill as amended and re-refer to finance, vote aye. All opposed, vote no.
Senator Norman, how do you wish to vote? Senator Norman?
He's voting. McDougal votes aye. Ayes 12, no 0. The bill as amended is reported and re-referred to finance. Okay. Senator Reeves, you got another bill?
Mr. Chairman, we just have that one bill that we had discussed at length in here, and I don't want to take up a lot of the committee's time, but it had to do with the honor guard and their ability to carry weapons when they do presentation of colors. Senator Morrissey was gracious enough to write up an amendment, so I do have an amendment to the bill.
All right. What's the amendment?
It's actually an amendment in the nature of a substitute.
Okay. I don't have a copy. Let me see.
1129.
It's Senate Bill 1129.
Mr. Chairman, if you remember, there was some discussion whether or not the bill was actually even needed. And the biggest point I had was to try to bring it forward so there's clarification amongst our veteran service organizations and the ability to do some of that. And so I think Senator Morrissey's revision to it, I think, kind of covers a little bit of what Mr. Benjamin had concerns about as well. So it's the same bill, just with a couple of tweaks.
The difference is on line 45. The provisions of this section shall not apply to any member of a congressionally chartered or officially recognized by the United States Department of Veterans Affairs, a veteran service organization, when such member is participating in a public ceremony on behalf of such veteran service organization, unless such member violates this section with malicious intent. So, can somebody explain that, what the point is?
Yes, Mr. Chairman, it just says that it's not going to apply to them. You can't just willy-nilly come out and charge these guys if they're exiting their vehicles with a rifle getting ready to get into procession for a parade, and for some reason somebody comes up and says, hey, you're brandishing or whatever. Now, if they get out of the car and they start waving that thing around and pointing it at people and they have malicious intent, then they can be charged, even though they're part of that. Or if they were marching down the road displaying colors in a parade, and I don't know, who knows what could happen, but they get out and they, use the rifle butt and beat somebody over the head, then they can be charged.
All right, somebody from Legislative Service explain the ramification of this, Charles?
Mr. Chair, I believe the patron has adequately explained what the intent of the substitute is. There is some concern as to whether or not this is actually needed or not. And we'll just point out that the brandishing statute has remained unchanged since 2005. So the question is whether or not, essentially what's happened between 2005 and now to make this necessary. But what the bill, what the does is exempts those people from the brandishing and paramilitary statute unless when participating in these public ceremonies, they have malicious intent to violate the statutes.
I think, is there...
Mr. Chair.
Yeah, I understand that in these, they have weapons, but they don't have any bullets, right? It doesn't say that these are not with bullets in it. Yeah, Senator Morrissey.
It's deeds.
Senator Deeds, okay.
I just wondered, Senator Reeves, was there a particular instance that caused you to bring this bill?
Mr. Chairman, Senator Deeds, so I go out and speak to our veterans group all the time, and my own post, American Legion post, they don't want to do honor guard or burial drops anymore because they're just hypersensitive to the firearm situation.
Yeah, I know.
And they were worried about this, so I'm trying to just bring clarification to those organizations so there's no gray for them and they can do it.
But there's never,
yeah, Senator Deeds.
Organizations do this all over the state. Has there been a situation where somebody's been charged with brandishing?
There has been a situation where people have been stopped and questioned, and you know how these things work, Senator Deeds. Then they're like, hey, we can't do that. We're not putting our members out there to do it. And I'm just trying to clarify whether or not we want to do that in the language. That's up to this body. I told them I'd bring the bill, so.
Okay, I understand there may be some members of the public, is that right? Want to say something? Is somebody from the public like to say something?
Yes, Mr. Chair. Andrew Goddard, please go ahead.
Good morning, Mr. Chairman. Andrew Goddard, Virginia Center for Public Safety. We believe the bill is totally unnecessary. Both of the code sections referred to in this bill have an intent listed in there. You have to be intending to induce fear. You have to be intending to furtherance of civil disorder. I can't imagine that these groups want to do either of those things. Basically, the way this bill is written is that this special group should be exempt from the law unless they violate it. Is that not what we all have with every law? If you don't violate the law, you're exempt from punishment under it. Yeah. So I think it's entirely unnecessary. Thank you.
Thank you. Anybody else from the public? Anybody else?
At this time, Mr. Chair, there are no other hands raised.
Okay. All right, any discussion?
Mr. Chairman?
Yeah, Senator Morrissey.
I think it drills down to this. The legislation that Senator Reeves has patroned is trying to make sure that those individuals that participate, whether it's a 4th of July parade or some other color guard scenario, are just absolutely not only consistent, their behavior is consistent with the law, but they are trying to make sure that nothing that they do is improper. I look at it as tightening it up. That might be the best words. With that, I move that we report.
Is there a second?
Chair.
I'm sorry.
Need to adopt the substitute.
Okay, we haven't, is there a motion to adopt?
Motion to adopt the
substitute?
substitute.
A second. All in favor of the motion to adopt the substitute, say aye.
Aye.
Aye. All opposed, no. Motion carries. The substitute's before us.
Motion to report.
It's got to go to finance.
Mr. Chair.
Senator Peterson.
And, you know, my devotion to Senator Reeves knows no bounds, but I actually think this bill is not a great idea, and here's why.
Oh, it's not?
When we put in a subsection B, effectively what we're doing is carving out an exception to the statute. This statute deals with illegal paramilitary activity, which is basically gathering and training with firearms with the intent to do harm to people, the intent to train people to commit acts of violence. So what we're doing is basically carving out an exception to that for when veterans groups gather. But they're not an exception to that because they're not part of that. So I think we send the wrong message when we create an exception to a statute that they're not part of. So I'm going to oppose the bill. I just don't think it's necessary. I think it sends the wrong message.
Let me say, as a veteran myself, I've never thought this statute had anything to do with parades, and I don't think it's necessary at all. I think it does send the wrong message, and for that reason, I'm going to vote no. So we have before us a motion to report the substitute. It does not have to go to finance. All right? Are we ready to vote? Mr. Sasslaw, where are you? Okay. All in favor of the motion to report, vote aye. All opposed, vote no.
Senator Norman, how do you wish to vote? I vote aye, Senator Norman. And the ayes 9, noes 5.
Ayes 9, noes 5. The motion carries.
Thank you, Mr. Chairman.
Yeah, Senator Reeves. Okay, now I want to announce that Senator Hashmi would like to strike her bill, Senate Bill 1340. Is there a motion to strike Senate Bill 1340? Been moved and seconded to strike Senator Hashmi's Bill 1340. All in favor of the motion, vote aye. All opposed, vote no.
Senator Norman, how do you wish to vote? I vote aye. Ayes 14, no 0.
Okay. Motion carries. Senator Stanley had indicated, he's here, Senate Bill 1105 and Senate Bill 1107 would like to PBI both bills. Is that right? No? Would you like to say something? All right, Senator Stanley.
Thank you, Mr. Chairman.
Okay, Senator Stanley. Senate Bill 1105.
Mr. Chairman, Senate Bill 1105 is a bill that this committee has seen before. I remind you of Keith Allen Harward, a gentleman who you all met in the Senate last year as the subject of a Netflix documentary where many of you appeared. This bill strikes specifically at the heart of what Mr. Harwood had to endure, 33 and a half years of being incarcerated for a crime that he did not commit. And that crime that he did not commit resulted in conviction based on what was called junk science, later discredited science. Mr. Harwood didn't get an opportunity to challenge that junk science, even though after his conviction it was determined to be junk science. Rather, he had to have a writ of actual innocence where DNA evidence exonerated him. Otherwise, he would still be incarcerated for a murder that he did not commit. Mr. Chairman, I believe there is a substitute.
All right, is there a substitute? I don't have a substitute.
Mr. Chairman, the substitute is now posted to LIS. It should be available online.
Okay, is there a motion to adopt the substitute? Is moved and seconded to adopt the substitute. All in favor, vote aye.
Aye.
Aye, vote no. Okay, substitute's adopted.
And Mr. Chairman, that substitute, which was crafted by Mr. Benjamin, removes the definition of discredited forensic science and replaces it with the plain meaning terms of discredited or contradicted forensic science. And it simplifies the definition. It also deletes the definition for covered offenses, so it applies to all felonies where junk science was utilized to obtain a conviction which is later discredited. And it also realigns the standard of proof that aligns with the changes that were made by this body to the writ of actual innocence that passed last year. Mr. Chairman, members of the committee, as quickly as I can, as you remember this bill from last year, this bill allows someone who may have been convicted of forensic evidence or forensic science technologies and uses that was then determined to be discredited, like bite mark evidence, blood splatter, those kind of things, to have a petition wherein they can have, if that is the crux of their case and the reason that they were convicted, then the Court of Appeals can review. It's a one petition attempt. It can be, not only is it filed, the petition can be dismissed summarily, but either way, it gives those that may be like Mr. Keith Allen Harward, wrongly convicted, a second chance at life, and certainly to make sure that in the criminal justice system, because we are not perfect, that we try at least to get it right. And that's the bill, Mr. Chairman.
The only question I have is the definition of junk science. So would somebody let Steve or Charles explain what the definition is of junk science?
There is no definition of junk science in the bill, Mr. Chairman.
How does it explain what, how do you do your petition? How do you articulate this information?
Mr. Chairman?
Yeah. Senator Morsi.
I'm not sure that I'll do a better job than the patron, but the enrichment, we received extensive publicity regarding bite mark evidence. That's what occurred was when the individual was convicted, an expert stated on the witness stand with certitude that this mark on the victim's body is absolutely consistent with the defendant's bite. I use the word bite in a dental sense. It was completely made up. There was no truth to it whatsoever. It was junk science. And I believe that the patron, when he uses those two words, is referring to at a later date when experts come forward and they say there's just no scientific basis for that evidence that was previously adduced as dispositive. Is that not correct, Senator Stanley?
Mr. Chairman, I'd answer the gentleman by saying that's exactly correct. I could not have said it better myself.
Senator Stanley, I'm well aware that 30 years ago, people, when it came to calls of fires, would say something is an arson. And the evidence has come to light that that was junk science, that a lot of people were convicted, or some were convicted anyway, of junk science when it comes to the cause of an origin of a fire. Because you would think the problem with fires is it burns up, so the evidence is not there typically, but they were doing this repeatedly.
Mr. Chairman, I think you recall a case even in our area where that junk science was admitted and resulted in conviction of someone whose conviction was later overturned. But, this is a very narrowly tailored exception to the actual innocence rule. And it's because, again, we don't always get it right. We'd be glad if we get it right some of the time. But then when we admit this kind of evidence, this newfangled forensic evidence, and then later have it discredited, those that languish in prison because of our restrictive actual innocence requirements don't get an opportunity, a single opportunity to challenge that science which is now discredited. Like Keith Allen Harward, 33 and a half years, we couldn't give him back his life. But he came and testified before this committee last year. I think it was powerful testimony, and this is the reason for that bill.
Okay. Anybody have any further questions? Anybody from Legislative Services like to say anything? Members of the public, does anybody would like to say something?
Mr. Chairman?
Yeah, Senator Obenshain.
Sorry. And I hope that the Commonwealth's attorneys will weigh in, but Senator Stanley referred to the evidence that will be categorized as junk science as newfangled forensic evidence. I think another phrase for that is cutting edge forensic scientific evidence. And I think that, if you look back, if we're looking backwards, we may have an easier time figuring out what junk science is. But if we look forward, I think that this is creating just an opportunity for endless litigation in every future case in which cutting-edge scientific evidence is used. And I don't know whether the Commonwealth's attorneys have any view on this, but I think this is an important one for them to weigh in on.
Mr. Chairman, if I may just address that.
Senator Stanley.
The state of Texas has this exact opening with it, and this has a sunset clause like the state of Texas has. They've had very few, I think no more than a dozen, of these petitions filed or to be heard. So it's not going to create endless litigation. And quite frankly, I'm sure everybody back in the 70s when Keith was wrongly accused called bite mark evidence cutting edge. But you know what? It was a farce. And it was propagated by forensic scientists that had absolutely no basis in fact and nothing related to science. And yet a man's freedom was lost for 33 and a half years. For your cutting edge science, I say, if it's proven cutting edge and it stands the test of time, then this petition does not apply to that. This petition applies to that forensic scientific methods that are debunked later, because otherwise we have no way to right the wrong to the people that are wrongly accused and convicted in these instances, these very rare instances. Thank you, Mr. Chairman.
Mr. Chairman, would the
Senator
gentleman from Rockingham yield for a question?
Morsi, go ahead, Senator Morsi.
Whether we call it advanced forensic evidence and what is now cutting edge a decade ago was not, isn't it important that if the new forensic evidence is dispositive to an individual's guilt or innocence, that we allow that person the opportunity to file a writ of actual innocence if it is dispositive?
Okay. All right. Is there members of the public? I think there's some that would like to speak. Am I correct? On this
Yes,
bill?
Mr. Chair.
Okay. Go ahead and start speaking. How many people are there?
Eugene Oliver, please go ahead.
You're speaking for the bill?
Yes, Your Honor. Thank you, Mr. Chair. My name is Eugene Oliver. I'm president of the Virginia Association of Criminal Defense Lawyers. And for all the reasons that have been stated, we support the bill and ask for your support. Thank you so much.
Thanks. Next.
Would those who wish to speak for the bill please use the Zoom feature raise hand? Sean Winetta, please go ahead.
Thank you, Mr. Chair. Thank you for allowing us to speak. I want to give time. We'd echo all the statements today. Sean Winetta with the Humanization Project. We support the bill and ask that you pass it. Thank you.
Next.
Sean Cardwell, please go ahead.
My name is Sean Cardwell from Northern Virginia. I'm a voting citizen. I support.
Mr. Chair, I could not hear the witness at all.
You go ahead. Can you speak again? We didn't hear you.
Hello, can you hear me?
What?
My name is Sean Cardwell, and I just want to say I support the bill as a citizen from Roanoke, Virginia. That is all.
Okay. Who else is there to speak?
Chuck Schlemp, please unmute and go ahead.
Good morning, Mr. Chairman. Can you hear me?
Yes, go ahead.
Mr. Chairman, I'm Chuck Schlemp, the Commonwealth's Attorney for Wise County and the City of Norton. Excuse me. And this morning, I believe Senator Obenshane asked for the Commonwealth's attorneys to weigh in. The Commonwealth's Attorneys Association, VACA, is not taking a position on this bill, but I would say that we generally, and I'm speaking for the general consensus of VACA, and for myself personally, believe that this is a good bill, that it supports, that it reaches a good balance between closure and conviction integrity. And so personally, not speaking on behalf of VACA, I like it.
Okay. Fine. Anybody else who would like to speak
Green.
for the bill?
Nate Green, please unmute and go ahead.
Nate Green.
Good morning, Mr. Chairman. Nate Green, Commonwealth's Attorney for the City of Williamsburg and James City County. Again, speaking on behalf of VACA, Mr. Slimp kind of jumped in front of me, but I would agree with everything he just said. At this time, VACA does not oppose this bill as being the appropriate balance between closure and conviction integrity.
Okay. Anybody else like to speak?
At this time, Mr. Chair, there are no others.
Okay. Is there a motion? Been moved and seconded to report the substitute and re-refer to finance. That's Senate Bill 1105 of Senator Stanley's. All in favor of the motion, vote aye. All opposed, vote no.
Senator Norman, how do you wish to vote?
Mr. Chairman.
Yeah, what's
Joe.
call? We got to get the vote done first.
All right.
Ayes 12, noes 1.
12 to 1. Senator Stanley got a bill out. Okay, congratulations.
Mr. Chairman, could you focus the camera on Senator Stanley? He was dancing up there for 2 minutes.
No, we can't. We don't want to watch the dance. Senator Stanley has another bill, 1107. Is this the one that's going by for the day? Explain.
Yes, Mr. Chairman, members of the committee, 1107 started out in its original iteration as removing the cap to med-mal that we had established a while ago. As the committee and the members know, the med-mal cap increases $50,000 a year. Right now it's at 2.4, and quite frankly, what we tried to do in the first iteration was just to remove that cap. In many states, we don't have medical malpractice caps, and in this state, we have this cap. But upon further reflection, what I was really trying to accomplish here was to make sure that as you're getting a packet handed out to you right now, that we try to take care of the rare occasions where somebody is injured by the negligence of a doctor, and those injuries require, through economic damages, millions of dollars in medical care in their future. And quite frankly, with the cap at 2.4, then that does not compensate those people. It does not pay for their medical care. It keeps that money out of the medical community, and instead the taxpayer bears the burden. First, there's a substitute to the bill, which then will demonstrate exactly what I'm driving at.
It's been moved and seconded that the substitute be adopted. All in favor of the motion say aye. Aye. All opposed, no. Motion carries.
Thank you, Mr. Chairman, members of the committee. You'll note on the substitute, which is on the last section of the handout I just gave you if you don't find it on the computer, that what this substitute does is restore the cap in its entirety. It leaves it exactly where it was, leaves the increases exactly where it is. However, it creates a safety valve starting on line 20 that says basically this: however, if the jury or a judge, if such action is tried without a jury, determines that there is substantial or permanent loss of impairment of a bodily function or brain injury or substantial disfigurement or any other special circumstance in that case that warrants a finding of the imposition of such limitation would deprive the plaintiff of just compensation for the injuries sustained, the limits recovery as set forth in this section shall not apply, regardless of the limit in the time that was in effect. If you look at your handout, and today we're here, Mr. Chairman, I'd ask that this committee hear from not only Nancy's family, but also the jurors that sat on that trial and that listened to that evidence and then made an award in excess of the cap only to find out that their hard work and their dedicated jury service was for nothing. Nancy was a wife, mother of two, a U.S. nuclear intelligence expert for the CIA. She went in for routine lower back surgery. Quite frankly, in cutting through Nancy, they cut an artery in her stomach, and she had hypoxia, losing oxygen for nearly 23 minutes. They were able to bring her back to life. She now has severe and permanent disabilities. Those severe and permanent disabilities require around-the-clock care and medical attention. The jury found, and it was uncontested, that the economic damages, that is the cost of her medical treatment alone, was $9.3 million. The 2.2 cap in effect at the time wouldn't even cover 1/4 of that. So this just modifies the cap, and you'll see in those handouts right now, modifies those caps in those rare instances when there is a Nancy, and this is why I call this Nancy's bill. Because the way the cap is in those rare occasions, Nancy's care now becomes the family obligation. Husband had to leave his job, care for her around the clock, has no compensation, cannot pay for the medical bills. Patients like these go on Medicare or Medicaid, that's us paying for it. Plus, on top of that, you're talking about less than 100% compensation to the medical doctors and the hospitals who provide the curative care for someone like Nancy. I'm reminded of one of my favorite Supreme Court justices of the United States who said, "To protect against injustice is the foundation of all of our American democracy."
Which one was that?
Thurgood Marshall. He also said that the measure of a country's greatness is its ability to retain compassion. Ladies and gentlemen, this is a small carve-out of the cap. It does not affect the cap in most cases. You'll see right there in your packet, which I've given you, here is a breakdown of the last 15 years of medical malpractice cases in the Commonwealth of Virginia. You'll see the top line, which is more heavily weighted, are in the 50,000, 100,000, way below the cap. If you look at the bottom line on that spreadsheet, what you see is instances over 15 years of no more than 3, 4, 5 a year where it's hitting the cap. I can't tell you how many of those were Nancy cases, but it's very rare when those things actually occur. And quite frankly, we need to make sure that when the Nancy type case occurs, that Nancy is protected, her family is protected, and quite frankly, the medical community is protected. Medical community says to you, and I know you've been lobbied, that this creates an unnecessary stress or burden. But what they're doing by proxy is asking you to protect a multi-billion malpractice insurance agency. You can see what the profits are in billions of dollars in profits that these insurance companies are making on these doctors. Studies have demonstrated that eliminating the cap or even putting on a cap does not lower premiums. The premiums still go up. Eliminating the cap doesn't change it either. In the last 15 years, ladies and gentlemen, the insurance industry earned $3.4 billion from these premiums with a profit of over 1.7. Quite frankly, I do not do medical malpractice, but I do know people who do. But it is rare whenever a settlement is offered where you're at the cap or greater, because to them, they know their limitation is no more than the cap, forcing many of these cases to trial. That puts a stress on the court system as well. And it is also a fact that more than 50% of all doctors are now employed by multi-billion-dollar health systems. In fact, one of the health systems here in the Commonwealth of Virginia, a not-for-profit, owns a medical malpractice insurance company, self-funds it, takes care of that. And the delivery of medical care, we must admit, is different than when the cap was first put in place. You also hear the argument that if you raise the cap, if you modify the cap in this safety valve, the sky will fall in. The cap will cause their premiums to skyrocket. And quite frankly, I would think competition in a free market is going to prevent that from happening. We've seen where there is a safety valve, such as Maryland and other places that have this exact language, that the premiums have not changed dramatically. Let's not forget either, for those that may not be an attorney in this case, that it is not so easy to file a medical malpractice case in the Commonwealth of Virginia. Quite frankly, it's very difficult. Before a lawsuit, you have to have a doctor put their license on the line and certify that a malpractice was committed. Without that certification, an attorney cannot file a complaint on their client's behalf. During the lawsuit, there are evidentiary rules which require a victim's evidence to be reliable and not based on, believe it or not, junk science. Quite frankly, the cap where medical malpractice insurance claims could be obligated to pay on the claims. We've seen in that spreadsheet that I've just given you that the cap has taken care of those claims, most of those claims that are below that limit. Public data, which you're in possession of right now, shows that in the past 15 years, there have only been 2,728 claims, and almost 90% were less than 1 million paid out. On average, there were only 4.4 claims per year in the $2 million cap range. This is not a case of trying to injure doctors or insult them during a pandemic. Quite frankly, it's just the opposite. This is not about the doctors, the great doctors who we have in the Commonwealth of Virginia, because most of them do such a great job, even though they pay the premium. This will never affect them. This is about actually equity and fairness. We see in medical malpractice claims, quite frankly, that those in minority communities and those that live at or below the poverty level who have these procedures done and malpractice committed against them are unfairly treated, and the cap is a part of that. This is about the insurance companies. Look at the profits that they're making. Quite frankly, profits that go into an insurance company's pocket rather than into the hospital's pocket or the therapist's pocket or the doctor's pocket who's taking care of Nancy right now. Who pays that? You know who pays it? It's us. What we're trying to make sure is, I think the Nancy cases are rare, but we can address them. We can't fix Nancy's problem, but we can use Nancy as an example. We can use Nancy to make sure that there are no more Nancys out there. Because what happened to her is utter tragedy. And we sat here in the General Assembly and arbitrarily decided what the limitations of her damages would be. You will hear now witnesses from the jury who were shocked by what they had awarded her was reduced to the cap limit. And that's the bill, Mr. Chairman. I thank you.
Senator Stanley,
Mr. Chairman.
with all due respect, I'm going to send this to Civil Law Sub. I had no idea it was going to take so long. We have a lot of people that would like to speak on the bill. We have a limited time this morning. So the Civil Law Sub is meeting at 4 o'clock this afternoon.
Yeah, Mr. Chair.
Senator Peterson.
We will be having a Civil Laws Subcommittee this afternoon at 4 o'clock. We have this bill. We have the bill on subcontractors. So we've got a really good docket, and we look forward to hearing from the witnesses this afternoon.
Mr. Chairman, if I may.
First of all, let me apologize to the people that were coming. I had no idea we were going to have this large a group. My understanding, and I misunderstood, I guess, that this would be put off at some other time. Yeah, Senator Morsi?
Mr. Chairman?
Yes, Kristen.
My apologies. Finance did ask for this bill, and today was our last meeting to get bills to finance.
Send it up there. Mr. Chairman, I've got a court appointment at 4 perhaps, I don't know yet, that I've got to go over and take care of, so 4 p.m. is not going to work for me. So if you want to send it to finance, we can do it there. Just report and re-refer.
That's not really going to work.
Mr. Chair.
How many people, there are a lot of people want to speak, and we don't really have time. How many people want to speak on the bill? We could be here all morning.
Mr. Chair, we have 11 speakers signed up.
I'll tell you what, we got let's put this off to the end and decide what to do. If we have time, the trouble is time. And it sounds like you're going to go on and on and on. This sounds like a good hour, right? And we don't have an hour.
Mr. Chairman, I'm done talking, but I remember 23, 30 speakers in the queue on other bills, and we gave them the right to speak.
All right, well, we don't have the time. I'm going to, all right, since this has, the finance needs to look at it too. All right, it'll go, we'll do this. We're going to send it to the subcommittee at 4 o'clock and then see what happens after that. Okay? Subcommittee at 4 o'clock, Senator Peterson subcommittee. All right, without objection, and I apologize for the people out there. I had no idea we were going to have that many number of people. Yes, Senator
McDougall. Mr. Chairman, I'm not going to be voting in favor of this in its substitute or current form, but I do have a concern about process. Are you planning on calling a meeting later today so that it would be able, of courts, after that subcommittee, so this would be able to move on if, regardless of what their recommendation is, because I'm assuming we've not changed our subcommittee process to be a final decision-making arbiter on bills.
If it's coming out of the subcommittee, it has to go to finance. We'll have to do something later this afternoon.
Because, Mr. Chairman, if we don't have another courts committee meeting today,
right,
then the action of sending it to finance would effectively kill it.
Well, let's send it to the subcommittee at 4 o'clock, and then can we have a meeting 6 this afternoon? Okay, yes. Let's tell you what. We'll go to subcommittee, then meet at my desk tomorrow morning, and if we have to, if it passes, it could go to finance then.
Mr. Chairman, will the witnesses be allowed to testify in this now new subcommittee?
For the subcommittee.
Mr. Chairman, point of order. Being that I may have an obligation, at least currently, I would ask the subcommittee chairman, understanding what my argument has already been and articulated here before that committee, could that be accepted? And then you get to listen to the witnesses, sir.
Mr. Chair.
Yes. Senator
I think
Peterson.
it's fair to say, other than perhaps Senator Survell and Senator Stanley himself, I am well aware of these issues, and his viewpoint is well articulated, and it will not be forgotten.
Mr. Chairman.
Thank you, Mr. Chairman.
Surville.
Yes, Senator Serval.
Thank you. And I'm a strong proponent of this bill, and I'd be happy to advocate not only for it, but also for Nancy, who Senator Stanley mentioned, who is my constituent.
Okay.
And so I'll be there for him.
Again, I apologize to all the people out there. I had no idea it was going to take this long. Okay? All right, so with that, we will send it to the subcommittee at 4 o'clock. If it comes out of subcommittee, we can meet at my desk. We'll meet at my desk tomorrow morning.
Thank you, I think, Mr. Chairman.
Thank you, Senator Stanley. Okay, Senator Morrissey, you got a bill, 1264? Senator Morrissey. Joe? Expungement of emergency and preliminary protective orders. Senator Morrissey. Okay, pass it by temporarily. Senator Sorrell, you have two bills. Senate Bill 1440 that's got to go to Finance. Senate Bill 1440. Well, I was told it's got to go to Finance. He's going to local government. Okay. All right, he's going to local government. Okay. In that case, we'll move on to Senator Deeds. You got subcommittee report.
I've got a subcommittee report. I had 5 bills. The first 4 listed there. I apologize.
That's okay.
The first 4 bills listed under the expungement subcommittee were expungement bills from Morrissey, DeSteff, Survell, and Lucas. We met on these bills for an hour and a half. That included a significant amount of public comment. The DeSteff bill, which is 1294, is somewhat contrary to the other 3 bills in that it imposes a fee, a simple $25 fee for an expungement petition. It's my understanding it was a request of a clerk or the Clerks Association. The recommendation of the subcommittee was to PBI the bill, and I would so move that.
Is there been moved and seconded that the bill be PBI'd as Senate Bill 1294? All in favor of the motion say aye. Aye. All opposed, no. The motion carries.
Got to vote.
No, I'm sorry, vote. You got to vote on the board.
Senator Norman, how do you wish to vote?
With respect to the other 3 bills, Mr. Chair.
So let me report. The bill has been passed by indefinitely by a vote of 10-3.
With respect to the other 3 bills, we came to a conclusion to incorporate 1283 from Morrissey and 1372 from Lucas into 1339 from Survell. And I would first move that we adopt a substitute for those bills and include all 3 as co-patrons.
We've already PBI'd 1283, right?
No. 1283, we need a motion to incorporate.
Oh, I'm sorry.
Likewise on the other incorporation.
Okay, we need to incorporate SB 1283 into SB 1339. And list Morrissey as a chief co-patron.
Yes.
Okay, Senator Bill. Yeah, Senator Lucas.
Okay. Okay, 1283 from Morrissey into 1339 by Survell. List them both as chief patrons. And my next motion will be to incorporate 1372 into 1339. List you as a chief co-patron.
What did we just do with 1283?
With 1280, what I'm trying to do, Mr. Chairman, is put both those bills, 1283 and 1372, into 1339 and list all 3 as chief co-patrons. John just told me I needed to have 2 motions. So The first motion is 1283 and the 1339 list both as chief co-patrons.
All right, it's moved and seconded to incorporate, transfer 1283 to 1339. All in favor of the motion, vote aye. All opposed, no.
Senator Norman, how do you wish to vote? Ayes 13, no 0.
Okay, Mr. Chair, the next motion is to put 1372 in the 1339 list. Senator Lucas is the chief co-patron.
Okay, is there a motion? It's been moved and seconded that to incorporate Senator Lucas's 1372 into Senate Bill 1339 and to list Senator Lucas as a co-chief patron. All in favor of the motion, vote aye. All opposed, no. Motion carries. Well,
Senator Norman, how do you wish to vote? Ayes 14, no 0.
Okay. So now we have Senator Serville's 1339.
Okay, and with that bill, Mr. Chair, what the substitute, have we adopted the substitute yet?
No.
Okay.
Is there a motion to adopt the substitute to
There
Senate
is.
Bill 1339?
Motion and a second.
Okay. All in favor of the motion to adopt the substitute, vote aye.
Aye.
Aye. All opposed, no.
Okay, what the substitute does is incorporate the provisions of Senator Serville's bill with respect to expungement, which is similar to the approach we took this past summer and the approach we took last winter, in that it expands expungement by petition. It allows for certain automatic expungement, and it creates a ceiling of the felony convictions. We also incorporated a provision from Senator Lucas's bill, the substitute she presented last week, that that includes some provisions that create liability on the part of commercial vendors, the people that report to the public criminal records. So they provide criminal records to employers. One problem is that just because we tell the state police, just because we expunge the offense, we can't always call that information that's already out there back. So we're imposing with that some liability on the part of the third-party vendors. And Senator Serville's bill had a provision on that as well. We liked Senator Lucas's language better. The difference between the Morrissey bill and the Lucas bill was Senator Morrissey included more offenses that could be subject to expungement. We preferred the more narrow approach, and we basically merged the Serville and Lucas bills into the substitute. And I'd move to report the substitute.
Okay. It's been moved and seconded to report the substitute and send it to Finance.
Mr. Chairman?
Yeah, Senator, who's that?
McDougal.
McDougal, sorry.
Senator Deeds, I guess Senator Serville's gone. Can you just go through in this final version what is automatically expunged, what you have the ability to file the petition to be sealed, and then what is expunged?
Well, I'm certain that I can't do it as well as Senator Serville could.
If Charles would be fine too, but I just think before we vote on it, everybody needs to be clear what's in it.
Okay.
Mr. Chair.
Yes, Charles.
That is recommended. There are what I'd say 4 expungement sealing provisions. The first one is the expungement by petition, which is just amends the current statute, which would allow persons convicted of essentially underage alcohol, possession of marijuana, and underage tobacco to petition for expungement. It also allows people who are charged with violations of, again, underage alcohol, possession of marijuana, and possession of controlled substances, when such charges are discharged and dismissed, to also be allowed to petition for expungement, which is the current expungement statute. The next section, which it allows, is if you're in general district court and your misdemeanor charge, if you're acquitted or it's dismissed with prejudice, you can ask at that time to have your charge expunged. There are provisions that require the Commonwealth to be allowed to object to it, and if the Commonwealth objects, then you couldn't have your charge expunged in General District Court. You could then, though, a petition in Circuit Court to have your charge expunged. The two other provisions deal with sealing of records, which the bill does define the difference between expungement and sealing. And for sealing, you can do it either by petition or an automatic sealing. And by petition, it is any person who's been convicted of a traffic infraction, a misdemeanor offense, with the exception of DUI and commercial DUI offenses, or any Class 5 or Class 6 felonies, or grand larceny or other larceny felonies, since grand larceny is an undefined felony, or if you received a simple pardon for any crime, you could file a petition seeking the sealing of conviction. The automatic expungement provision only apply to Class 3 or 4 misdemeanors that are reported to the CCRE, or for the violations of underage alcohol, possession of marijuana, or drug paraphernalia involving marijuana. And those would allow for the automatic sealing, and there is criteria which would allow for the automatic sealing. The automatic sealing provision also includes that any charge for which the court disposes of records in accordance with its statutory required destruction timelines would also be considered sealed. So if the court has to destroy the record, that would also be eligible for automatic sealing.
Okay. Any further questions? All right. I understand somebody from the Crime Commission wants to say something.
Mr. Chairman,
Yeah. Who's this? Okay. McDougal, Senator McDougal.
Make sure I understand. So any conviction, so what can you have sealed? Only Class 5 and Class 6 felonies, or any felony?
What you can have sealed is only for felonies. It is only Class 5 or Class 6 felonies or larceny felony offenses, or if you receive a simple pardon. So if you receive a simple pardon for any felony offense, you could get that felony sealed.
So, Mr. Chairman, just to be clear,
Senator McDougal.
Embezzlement is a larceny offense. So if you embezzled $500,000 from your employer, you still would be entitled to these sealing provisions if you so exercise.
That is correct. That is correct, Mr. Chair.
Thank you, Mr. Chairman.
Okay. Colin from the Crime Commission. Colin,
Good morning, Mr. Chair.
Yeah. No.
Yes, good morning, Mr. Chair. Colin Draper from the Crime Commission. I don't have anything to say. I just signed up for if there were questions about Senator Lucas's bill, but that's now been rolled into Senator Servel's bill. So no comment from the Crime Commission.
Okay.
Thank you, sir.
All right. Anybody else would like to speak from the public? From the public? Rebecca
yes,
Wynn? Go ahead.
Rebecca Wynn, please unmute and go ahead.
Hi there. I'm with the NAACP. I'm a chair for the Hampton branch. I'm also a licensed attorney in the state of Virginia. And I am in favor of Senator Lucas's bill because we're speaking about people who have already served all of their time and met all of the requirements. Her bill also provides for an 8-year period of time where no further offense was made. We are one of the most unforgiving states when it comes to people being able to rehabilitate fully back into the community. Again, between that 8-year period of time and people having fully met all of the terms of a court's order, we need to be able to allow people to fully be employed and meet their full potential. It's not only good for them, it's good for our economy. Further, I'm in favor of the automatic expungement because it's an undue burden on our courts. It also is an expense on our courts when they could be attending to other needs and other cases. And further, it's an expense on the newly rehabilitated person. They have to go get an attorney.
Yeah. Okay, go ahead.
Mr. Chair.
I was going to say it's all.
Wrap it up. Thank you.
Mr. Chair, we conducted public hearings in the subcommittee. If we're going to do it again, we may as well not have subcommittees.
Okay. All right, is there a motion?
I made a motion to report.
It's been moved and seconded to report.
Mr. Chairman,
Senator Steve Benjamin.
my concern is that it appears to me that,
It's got to go to finance.
okay, maybe going forward then, what needs to be addressed is the fact that prosecutors are not permitted to provide covered convictions to defense lawyers. And this is important because prosecutors have a constitutional obligation to provide this information so that it can be used in the defense of a client. So I can make a suggestion here, or I can forward it to be taken up in front of finance, but that provision needs to be modified.
Mr. Chair.
Senator Peterson.
Yeah, and I have a number of questions, and I'm not sure when's the right time, and it may have come up in subcommittee, but for example, in a case, whether it's civil or criminal, I'm allowed to impeach a witness if they have a prior felony conviction or a conviction for a crime of moral turpitude. Is that going to be changed in any way?
Well, let me say,
Mr. Chairman, Senator Peterson is correct. That would be prohibited, or you wouldn't even have that information.
Right.
And I don't know if the bill also prohibits impeachment. I'll make this suggestion. At lines 446 through 449 and lines 509 through 512, delete the words "for the Commonwealth" and delete "public" when it refers to public duties, and insert at the end of that sentence after duties or practice of law.
Well, I would make that motion if that would.
Is there a second?
I got to read. Well,
is there a second?
Hold on, I got Senator Stewart talking to me. Senator Benjamin, does that cover both civil and criminal situations, or just criminal?
Mr. Chairman, Senator Peterson, that does appear to cover both civil and criminal. And what it provides for is it enables attorneys to disclose that information in the performance of the practice of law.
Okay. All right, well, then I would make that motion.
Is there a second? It's been moved and seconded that the line amendment be adopted. All in favor say aye.
Aye.
Aye. All opposed, no. Okay, motion carries. Now, we have a bill been gone through subcommittee. It's not a perfect bill. It's got to go to finance, but to move it along is a motion. Senator Deeds is making a motion to report the substitute and re-refer the substitute to finance. All in favor of that motion?
Mr. Chairman?
Yes, Senator
Sherville. Thank you.
You
I
back?
guess-
Okay.
Yeah, I guess you started my bill while I was out of the room.
It goes quicker that way.
So, I guess the bill is as it came out of subcommittee with a couple amendments that just got made. Is that the deal?
Yeah. Yes.
Okay, I'm fine with that.
And Mr. Chairman, it's Steve Benjamin.
Go ahead, Steve.
Reading further, it also appears that lines 593 through 599 should be struck because that language explicitly prohibits impeaching a witness with this information.
Okay.
That addresses Senator Peterson's concerns.
Okay, we need another line amendment.
I'll make that motion.
Is it okay? All in favor of the motion for the line amendment that Steve Benjamin just explained, say aye. Aye. All opposed, no. Okay, we now have a Senator Deeds report and re-refer the substitute with the line amendments to finance. Is that where we are? Senator Deeds?
Benjamin just said we had to delete those sections.
They're not in the room? How are we going to do this if everybody's not going to be here? How many people we have here? Okay, you got the proxy. All right. All in favor of the motion to report the substitute with the line amendments and re-refer to finance. Vote aye.
Senator Norman, how do you wish to vote? Ayes 8.
Senator Norman votes aye.
Ayes 9, noes 3, and 3 abstentions.
9, 3, and 3. So the bill has been reported and re-referred to finance. It's not a perfect bill, but it will continue the process.
Mr. Chair.
Yeah, Senator Peterson.
And I apologize for speaking after the fact, and I support expungement reform. I think there's a couple critical details on public safety that need to be checked out, particularly on protecting elderly, protecting kids. And so until I get certitude on that, I cannot support the bill. I got to be absolutely certain that we're doing that.
Okay. Now, Senator DeSteff has Senate Bill 1294.
We've already PBI'd that bill.
Okay, we PBI'd, okay.
So the next bill in the subcommittee was 1406. It was a marijuana legalization bill. We had 2 meetings, 4.5 hours. It included 20 minutes of public testimony. It was just not enough time for this huge bill. I'd first move a substitute, which represents the subcommittee's work.
Okay.
Get the substitute before you. I'd move that.
Senate Bill 1406 has been moved. Is there a second? And seconded to report Senate Bill 1406. Any discussion? It came out of the subcommittee, so we've had a public hearing. Anybody feel compelled to say something?
On the substitute, we just have to adopt it.
Okay. Okay. All in favor of adopting the substitute, say aye. Aye. All opposed, no.
Okay. I just kind of want to summarize what the substitute does, and I'm sure that other people will have things to say. The substitute makes it legal to use marijuana in a private setting for adults July 1 of this year. The bill came to us from the rehab committee and it had scaled back the governor's proposal to create a marketplace January 1, 2023. And the bill came to us from the rehab committee. It established a new agency to oversee marijuana, and that agency marketplace would be set up January 1, 2024. Well, it was still a 200 some odd page bill. 13,000 lines were in the bill when it came to us before we adopted the substitute. We made a number of other changes in that bill besides making it legal to use marijuana July 1 of this year. We wanted to provide fairness to juveniles in the penalty. We wanted to bring the penalties closer for public possession, closer to public possession of alcohol. We accelerated the penalty for using marijuana in public and the open container provisions of the bill. We accelerated the punishment for using while driving a commercial vehicle or a school bus. We accelerated the punishment for delivery of the marijuana to an inmate and for use and possession on public school grounds. Those changes were primarily made in Titles 4.1 and 46.2, those parts of the bill. The rest of the bill that came from the Rehab Subcommittee that established the agency, that established a regulatory scheme and allows for home growing, we put a reenactment clause on all of that. It's my understanding the reenactment clause, and I've not seen the specific precise language of the substitute yet, but my understanding is that would allow the regulatory scheme to begin to be established. But we just wanted more time to be able to review the provisions of the bill. It's and this is my 30th session. I don't think I've ever seen a bigger bill that makes more substantive changes. Often when we recodify titles of the code, you'll see big bills, but they don't make that much change. This makes a huge amount of change. We didn't feel like we could get intimate enough. Let me a couple of other things. There's an automatic expungement provision of this bill for possession of marijuana. It also related to paraphernalia. In discussions with the Supreme Court, we couldn't figure out how to parse paraphernalia. Know that paraphernalia was related to the use of marijuana or other drugs. So we stripped the automatic expungement of paraphernalia out of the bill. We continued, it still has some automatic expungement provisions for simple conviction of small amounts of marijuana, but that part of the bill has a delayed effective date because the Supreme Court indicated that the work that has to be done at the court and in the state police database is going to take 2 to 4 years to get completed. So we've got a delayed effective date on an automatic expungement provision to 2023. And understanding that may have to be moved back even more. That's kind of a summary of what we did. I'm sure there are other people that have things they want to add to that.
Mr. Chairman.
Senator Sherrill.
Thank you. Just one other thing I want to note. I got a call from over the weekend from the Supreme Court who noted that the automatic expungement methodology used in this will cost taxpayers $2.8 million more than the methodology that's used in what we just adopted in Senate Bill 1339 with regard to sealing. The surgery that's going to be required to make that fix is something that I think we can't do in committee right now, but I think the Finance Committee will probably need to do when it gets over there, given that it has a fiscal issue. So I just wanted to note that for the committee. But secondly, Mr. Chairman, I had a motion I wanted to make to also speed up one additional statute in terms of being effective July 1 of this year, and that is Section 24.2233, which is on, if you have the bill in front of you on lines 12,077 of the bill.
Is that the new substitute?
Yes, I believe it is. And I will say facetiously that Senator Saslaw requested this change. But one of the curiosities of the elected official removal statute is that one of the bases upon which an individual can petition a circuit court to remove any elected official in Virginia from office is possession of marijuana conviction. Mr. Chairman,
Okay, all right.
So anyways, Mr. Chairman, I would like to also include that statute within the statutes that are sped up for modification effective July 1 of 2022. I think.
Okay, let's get serious now.
I'm being serious, Mr. Chairman. I mean, I think that one needs to be sped up.
You want to do what?
The substitute speeds up the effectiveness date of several statutory changes to July 1 of this year. Senator McClellan started the trend, and then we added a bunch of other statutes to her motion. I would add the changes that we're making to 24.2233 to be effective July 1 of 2021 this year as well also.
Is there
Second.
right, moved and seconded that you're doing, I'm not sure what you're doing.
Mr. Chair, have we already adopted the substitute?
We've adopted the substitute.
We've adopted the substitute.
What the change he's talking about is there's a section of the code that says that you can remove someone from elected office for possession of marijuana.
Okay.
And since we're saying that you can use marijuana legally July 1 of this year,
Okay.
it's accelerating the repeal of that section.
Mr. Chairman.
Yeah, Senator Sherrill.
Thank you. Senator Eben just pointed out to me that for some reason his bill doesn't actually strike that. So then my motion then, Mr. Chairman, would be that with regard to the substitute, I'm going to amend my motion that we strike lines 12,086 to 12,087 of the bill.
Mr. Chairman.
And whatever other surgery needs to be made, and speed that up to July 1 of 2021. That would be my motion.
Mr. Chairman.
Senator
Chair.
Who's speaking?
Senator Eben.
Senator Eben.
I think that Senator Sherrill wants to just strike the part referring to marijuana, not the part about controlled substances. On line 12,087.
Mr. Chairman.
Let's get it right. Yeah, Senator Sherrill.
Senator Eben is correct. So I'm sorry. The motion would then be to strike or marijuana on 12,087. and speed it up to July 1 of 2021.
So just strike it. Okay. All right, it's been
Chair.
moved to, the line amendment's been moved. Is there a second? Senator Deeds seconds it.
I'll second it.
All right, all in favor of the motion, the line amendment, say aye. Aye. All opposed, no. Motion carries. Okay.
Mr. Chair,
Mr.
just so
Chair.
I have some clarification on that amendment that was made. The amendment would be to remove marijuana offenses from 24.2 to 33. Is that the intent of the amendment?
That's the intent, Mr. Chairman.
Well, let's,
It looks like there's a couple other edits to make to accomplish that, but that's the intent.
well, how long are we going to be here to do this? I mean, we spent 4 hours the other day, the subcommittee.
We did two different meetings, and Senator Abbott and Senator Lucas have spent countless hours on this. But we spent 4.5 hours in our subcommittee on this.
All right, there's a motion to reconsider the vote by which we adopt this line amendment. Is there a motion to reconsider it so we can get it fixed? Second. All in favor of the motion, say aye. Aye. All opposed, no. All right. Senator Sherville, would you like to, or have Charles explain it better?
Sure.
Somebody? Charles, explain it better, if you can.
Sure. So, Mr. Chairman, under the current law, you can be removed from an elected office for a marijuana offense. The bill, as proposed by the Rehab Committee, kept those provisions in. Senator Servel's amendment would eliminate that from the removal section, so that if you have a marijuana offense starting July 1, 2021, you cannot be removed from elected office.
Okay, that's all it does, right? Okay.
That's all it does.
And that's been moved and seconded to adopt that line amendment. Any questions? All in favor?
Mr.
Yeah,
Chair?
Senator Boysko?
If we are going to be legalizing it, would there be no offense to be prohibited from office then?
Except that, clean
No,
it up.
Mr.
Charles?
Chair, to answer Senator Boysko's question, there are a number of offenses that are, even though it is legal, there are still a number of offenses that are in the bill. For example, consuming marijuana in a public place is a class 4 misdemeanor. That would be even though it is a legal substance, that is still going to be a criminal penalty. Or operating a school bus while consuming marijuana is a criminal offense. So if you are an elected official and you're driving a school bus and you're consuming marijuana, you would have a class 1 misdemeanor violation.
Okay, that answers the question.
As the bill is from rehab, you could be removed from office. But with the line amendment that Senator Servel just made, that would not require your removal from office.
Okay.
Mr. Chair,
Yeah,
I'd just
Senator Boysko,
I'd just like to confirm. So everybody else in the state would still be subject to a penalty, but members of the General Assembly would have the...
No, you would, Mr. Chairman.
I'm just trying to understand this.
Mr. Chairman, members of the General Assembly would still be subject to the misdemeanor. They just would not be removed from their political office. So they would still be a member of the General Assembly. They would just have a misdemeanor on their criminal record.
Okay, all right.
Mr. Chairman.
Yeah, Senator Lucas.
Okay, I guess that means that any member of the legislature that has a card from the Department of Health Professions, they would be safe to have their, I guess maybe to have their medications with them. Is that correct?
Mr. Chair, the amendment does not affect anything to deal with the card and the medication you would receive under the bill. Because if that provides you a valid exemption from the criminal offense, you would not be convicted of the criminal offense.
Okay. All right, any other questions?
Mr. Chairman?
Yeah, Senator Schwarber, we got a line amendment here. Go ahead.
I do, Your Honor. Mr. Chairman, I just want to make clear. I don't know what motivated somebody to single out marijuana for being grounds for removal from office in a recall petition, but there's probably 500 other crimes that aren't specifically mentioned that might not result in removal from office. And if we're taking possession off the books, first of all, I don't even think we should be able to be recalled for marijuana possession per se to begin with, but beyond that, there's many other crimes that aren't even included in the statute. I just think it needs to come out.
We got an amendment before us. It's been moved and seconded that the line amendment be adopted. All in favor say aye. Aye. All opposed, no. Okay. Is the bill ready to be?
Move to report as substitute as amended.
Been moved and seconded that the substitute as amendment be reported and re-referred to finance.
Mr. Chair, could I ask another clarifying question, please?
Go ahead.
Mr. Chair, with the reenactment clause, I would like to make certain that we still have the ability to move forward with the planning for the new agency, that's not going to slow anything down. Could we just get some clarification on that, please?
So, Mr. Chair, to answer Senator Boysko, and perhaps these details need to be worked out more in the process, but the reenactment clause right now would essentially provide anything that is to become effective July 1 this year will take effect. Anything that is to be effective in 2023 will need to be reenacted. It does create the potential problem of going down this path and having some things become law and then some things not becoming law. So, for example, the repeal of the possession marijuana offense, which is due to take place July 1, would become law. That would not be part of the reenactment. But everything related to all the new code sections in 4.1 would need to be reenacted. So anything that is supposed to take effect July 1, which includes some of the setting up of the board's ability to start making regulations, would take effect, but would not need to be reenacted. So you could have the board being created, you could have regulations being promulgated, and they would have some sort of force of law because they would not need to be reenacted. But that is what the reenactment clause does.
Okay. Are you ready to vote?
Chairman.
Yeah.
Mr. Chairman,
Gotta move
Senator
forward.
Norman, can you hear me?
Yeah, Senator Norman, go ahead.
Mr. Chairman, just an observation from the peanut gallery. One, this is the definition of a problem of an omnibus bill. Had this been broken down into several bills, we would not be wrapped around the axle. Right. Secondly, this is legislation that is continuing to be drafted by committee, and that is never a good approach, even though I support some of the objectives of this. This is not good.
Thank you for your advice. Okay, we have a motion to report and re-refer to finance. Yes?
Mr. Chairman, before I vote, could I ask a question?
Yeah, very quickly.
Is it still a felony to grow marijuana given the new enactment clause?
I don't know.
Mr. Chairman?
Yeah, Senator Sherrill.
My recollection that one of the amendments that we made in subcommittee that I believe we've adopted now was a specific prohibition on growing at home, so the law was clear. Senator Deeds, I thought we made that amendment, didn't we?
You know, my understanding is that the growing provisions will not take effect until January 1, 2024. And then you'll be able to have 2 mature plants and 2 immature plants at home. But until that, I'm not sure we made an amendment to speed that up.
Mr. Chairman, so we're going to legalize marijuana, but it's going to be a felony to grow it. That is absurd.
Is that the case? Charles?
Mr. Chair, the civil penalty for simple possession of marijuana is being eliminated in the substitute. The remainder of the marijuana offenses will remain as is until January 1, 2023, provided the General Assembly reenacts this legislation next year. And that's, I would add, one of the things that Senator Deeds did want to speed up, and the subcommittee made a recommendation, was to speed up delivery of marijuana to prisoners. In the substitute, that's not necessary because the existing law regarding delivery of marijuana to prisoners will remain in effect until January 1, 2023.
Okay. All right. Thank you.
That didn't need to be sped up. So to answer Senator Stewart's question is, yes, the manufacturer of marijuana will still remain illegal under the 18.2 sections, until this bill, the rest of the bill takes effect in January 1, 2023.
Are we ready to vote? We got a report, to report the substitute and with line amendments to re-refer to finance. All in favor, vote aye. All opposed, vote no.
Senator Norman, how do you wish to vote?
Senator Norman votes aye.
Ayes 9, noes 5, 1 abstention.
Okay, thank you. The bill is reported and re-referred, 9, 5, and 1. Okay, thank you. I'm going to turn the chair over to Senator Deeds briefly. Senator Chase has 2 bills to be heard.
Thank you, Mr. Chairman. Can you hear me okay?
I'm sorry, Senate Bill 1230.
All right. Can you hear me okay?
Yes.
All right. Fantastic. Senate Bill 1230 is a bill related to criminal cases and creating more transparency. According to the CDC, 1 in 4 women and 1 in 7 men will experience physical violence by their intimate partner at some point during their lifetime. About 1 in 3 women and nearly 1 in 6 men experience some type of form of sexual violence during their lifetimes. This Out of the Shadows bill seeks to help victims of domestic violence by creating more transparency in the judicial system as it pertains to criminal proceedings. As it stands, the criminal proceedings for domestic abusers are filed in JDR court, where proceedings are protected and unavailable to the public. This bill requires that the criminal proceeding instead be transferred to General District Court so that the criminal proceedings may be made available to the public. Mr. Chairman, if someone punches an individual in a bar, it's public record and it can be found on the public case information system. If an individual punches their spouse, however, it's shielded under confidentiality rules in juvenile and domestic relations courts. And here's the problem. It's the family abusers. They are getting the same confidentiality as juvenile offenders. And Mr. Chairman, this bill changes that on a case-by-case basis. Thank you.
Well, it allows, let's see, the offender, provided the offender and the victim are both 18 at the time of the offense, upon the petition of a victim, doesn't say anything about the victim's lawyer, and or the defendant's lawyer. Doesn't require the defendant's consent at all to transfer the proceeding. Just depends on where you get the tougher judge, I guess.
Mr. Chairman.
Senator Morrissey.
On that same line, you mentioned that it doesn't require the consent of the defendant. There's no mention of the imprimatur of approval by the Commonwealth's attorney either. I have a couple of questions for the patron.
Yes, sir. Go ahead.
Senator Chase, is the reason for this legislation that you want to have the victim be able to publicize the verdict or the decision in J&D court that you otherwise would not be able to do? Was that the genesis of this legislation?
No, thank you so much for asking that question. The primary reason for this bill is to create greater transparency. Can you hear me okay?
Yes.
The main reason is to create greater transparency. Currently, domestic abusers are basically hidden in the shadows. This is not for any type of publicity reasons at all. It's basically to ensure that abusers are not protected under the current law.
Mr. Chairman?
Senator Morrissey.
If you look on your legislation, you're talking about the victim and the alleged abuser being over 18, correct?
That is correct.
And your concern is that the doings in J&D court are hidden in the shadows, correct?
That is correct.
Are you aware, Senator Chase, that in juvenile court for a victim over 18 and the the defendant over 18, the exact situation that you're describing, that is open to the public? Were you aware of that?
I'm not aware of that. I had this bill came to me from an attorney who practices law and was advised that this is not indeed the case. And in fact, they're in court right this moment. But my understanding is that that is not the case, which is the reason for bringing the bill forward.
For one final question, Senator Serville, would you confirm that in J&D court, if there's a victim over 18 and a defendant over 18, that in J&D court, those proceedings are open to the public?
Mr. Chair, my understanding is that with the victim's an adult and the defendant is an adult, they are totally public. So I'm not really clear about the premise of this bill. Maybe counsel could clarify that.
Mr. Chairman.
Senator Obenshain.
While I trust Senator Servell's reading of the law completely, perhaps we could hear from our committee counsel as well as to whether that is the case.
Mr. Chairman, I am not an expert at juvenile and domestic relations court. It has been my impression, however, that the records that pertain to adults are available for public inspection. The difference is that the database of charges and convictions that can be accessed online through the general district courts, there is no such database for juvenile and domestic relations court. And so my understanding is that a member of the public can go to the clerk's office of any particular juvenile and domestic relations court and request those records, but cannot access them online.
Mr. Chairman?
Senator Morrissey.
Question of Mr. Benjamin. Mr. Benjamin, is it not true, with your response a moment ago was with regard to records, but in a situation where the victim is an adult, the alleged perpetrator is an adult, aren't those proceedings in J&D court open to the public?
Mr. Chairman, Senator Morrissey, yeah, I think they are.
Okay.
Legally. However, anybody who ever goes to a juvenile domestic relations court sees that all the doors to those courtrooms are closed, and even attorneys, I think, are a little hesitant to enter these closed courtrooms. So practically speaking, I don't think the public feels free to go in there, but I think that they have the right to.
Okay, the bill's before the committee. Are there additional questions?
Mr. Chairman?
Senator Chase.
Just a final statement that I would like to make. I want to make sure that this is searchable in the public case information system. As our counsel has suggested to us, while the proceedings may be public and available, it is not searchable in the public case information system, which is what I'm seeking to change, to make there more transparency and more searchable to the average citizen, that they can be able to find this case of abuse and the abuser in the public case information system. That's what I'm looking to change in this bill.
Thank you, Senator Chase. Are there people is there anyone who wants to, in the public, who wants to comment?
Mr. Chair, there are people who want to comment. Sean Winetto, please unmute and go ahead.
3 minutes aside. 3 minutes aside.
I'll be very brief, Mr. Chair. Thank you for letting me speak. Sean Winetto with the Humanization Project. We oppose the bill. We believe that these issues are best addressed in domestic relations, and we believe the database should be held there as well. The public can access it, and we ask that you guys the bill. Thank you.
Thank you. Who's next?
Sandra Carrison, please go ahead.
Thank you. Mr. Chairman, members of the committee, I have a number of concerns. The court opposes the bill. I'm with the Office of the Executive Secretary at the Supreme Court of Virginia. The bill would reduce the current clarity between the respective jurisdiction of the JDR and the district courts. The bill would result in increased numbers of hearings and cause delay attendant to transferring the case between the juvenile court and the general district court. It's unclear what is meant by disposition, because often these cases are conducted in one hearing, the trial and the sentencing in one hearing in the juvenile courts. Depending on what is intended, and line 124 says disposition, line 122 says any criminal proceeding, depending on what is intended. If the bill means transferring for sentencing only, then we have multiple hearings, increasing those numbers. If it means transferring prior to that time, speedy trial rights could be implicated, especially if it could implicate a preliminary hearing transfer for someone who is being held pre-sentence. The bill is burdensome to clerks because currently the transfer provisions permit that if the court does not have jurisdiction, the JDR court, over, for example, they discover this is not a family and household member with the particular circumstances that are involved. That's why it's in the Juvenile and Domestic Relations District Court in the first place, with those particular nuances. If they don't meet that statutory definition, the whole case is transferred. It's not part of it is transferred. So this case is burdensome to clerks. And finally, with regard to the database issues, there are bigger implications, and there are ongoing discussions about this and recognition of the need to weigh the public's access to these records and the family and children's who may be involved, their privacy.
Okay, thank you, ma'am.
So, thank you.
Are there other people who need to speak? Okay, the bill's before the committee. Are there motions?
Mr. Chair, motion to pass the bill indefinitely.
Is there a second? Okay, is there a discussion or further motions? If not, please open the roll. Motions to PBI.
Senator Norman, how do you wish to vote?
Senator Norman votes aye. Senator Norman votes aye.
Thank you.
Okay, the bill's PBI'd. Senator Chase, you've got another bill, and I'm going to turn the docket back over to the Uber chair.
Thank you, Mr. Chairman. Senate Bill 1231 is similar to my last bill, so I'm just going to keep it quick here. The main difference between the last bill and this bill has to do, states that any future hearings changing the disposition shall incur at the Juvenile and Domestic Relationships District Court, and any disposition changes shall be filed with the General District Court within 10 calendar days of the entry of a modifying disposition order. So it changes lines 12 through 21.
Okay, Senator Sasslaw moves to PBI the bill. Is there a second? Second? I can't hear. Okay, then it's moved and seconded to pass the bill by indefinitely. Any discussion? All in favor of the motion, vote aye. All opposed, no.
Senator Norman, how do you wish to vote?
Senator Norman votes aye. Senator Norman votes aye.
Check. Thank you.
Okay, thank you very much. Yes.
Ayes 14, noes 1.
Thank you.
Okay, thank you. Senator Peterson, Senate Bill 1234.
Thank you, Mr. Chair. Senate Bill 1234. I'm going to do this based on memory. I don't have my folder in front of me, but first of all, there's a substitute. If the substitute could.
I just posted it, Senator Peterson.
Great, thank you.
Is there a motion to adopt the substitute? All in favor? Is there a motion? Been moved and seconded to adopt the substitute. All in favor say aye. All opposed, no. All in favor say aye.
Aye.
All opposed, no. Motion carries.
Okay. All right, Mr. Chair, let me give a little bit of background, and I don't know if you can see me because Surville's standing right in front of me, but this bill arises from what used to be unique but will be a more common factor of our increasingly international commerce. It has to do with attorneys that are licensed in foreign countries that come to the United States, that attend a United States law school, obtain an LLM, and then, which is basically an advanced degree, not the 3-year JD, but a 1-year advanced degree, and then become licensed as attorneys in another state because they passed the bar exam for that state. This, to date, they're not allowed to sit for the Virginia bar because if you don't go to an ABA certified law school, which is to say a law school that's in the United States, you can't sit for the bar exam. Even if you're practicing law, even if you're an experienced attorney, you can't even sit for the bar exam. And I think that's an inequity because, I mean, we allow people to sit for the bar exam if they read the law. We have all sorts of exceptions to sitting for the bar exam, but for some reason, foreign attorneys who, again, have obtained an LLM and been licensed in another state are now not even allowed to sit for our bar exam. So I brought this bill. It's been through a couple of amendments. I do have a witness, and let me just speak biographically. I'm going to introduce the speaker. Hopefully he's in the waiting room. A young man, went to Fairfax High School like myself, was educated in England, became a barrister, and then came back to the U.S., got a LLM from Scalia Law School, and is a licensed member of the bar in New York and Maryland, but is not even allowed to sit for the Virginia bar. And he's worked with me for a couple years. He's a crackerjack attorney, and I know he's on the line. If you can speak as a witness, Mr. Chair.
Okay. Can you say who you are?
Thank you, Mr. Chairman, and thank you, Senator Peterson. My name is Ibnul Khan, and I'm in favor of Senator Peterson's bill. And I not only speak on behalf of myself today, I speak on behalf of a class, those situated like me, and this is thousands of folks around the United States, but particularly in the Commonwealth of Virginia. We have Richmond Law School. I teach at Antonin Scalia Law School to the LLM class, who happen to be situated in this class, and UVA LLM grads as well. The inequity, as Senator Peterson described, is essentially that not only can we not waive in, we can't sit for the bar exam. So if you look on the Virginia Board of Bar Examiners website, it says that you must have a JD, even if you've been practicing 5 years as an attorney, to waive in, or you must have a JD to sit for the bar exam. So I'm licensed in New York and Maryland. I'm licensed in federal courts there. I litigate all over the country, but I can never practice in Virginia. So I respectfully request that the bill move forward so thousands of folks like myself can become licensed in Virginia one day. Thank you for your time.
Thank you, Mr. Chair. And
Mr. Chair.
Speak say your name.
Steeds.
Deeds, yes, sir.
I just want to ask Senator, this just allows somebody who's been educated outside of the country and licensed in another state to apply for the bar examination?
Exactly, just to go through the same bar process that we all did.
Mr. Chair?
Yeah, Senator Morrissey.
I'm 100% in support of this legislation. An LLM is a master's in law. I actually have an LLM from Trinity College in Dublin, and almost every other country that I can imagine where they have an LLM, these individuals in Europe are coming to the United States. They're sitting for a bar exam, and they're taking it, and they're becoming superb practitioners. The fact that Virginia doesn't even let the person who has a law degree from another country, who's got an LLM in America, doesn't even let them sit for the bar in Virginia is nothing short of despicable.
Well, Mr. Chairman.
Mr. Chairman.
Senator Norman.
Mr. Chairman, I take umbrage at Senator Morrissey's characterization of it, but I am curious, do we have any positions from the Virginia Board of Bar Examiners or the Virginia State Bar or the Virginia Bar or the Supreme Court on this issue?
Mr. Chair.
Yeah, Senator Peterson.
I spoke with Anita Poston last week to try and get this right. I'm not going to speak for her, but unless she speaks in opposition, I think that should be where the bar is. I've been working with the Supreme Court. I think they're good. Again, this is just simply letting people sit for the bar. It's not trying to give anybody a leg up. It's just basically getting on the same footing of pretty much every other state at this point.
If Senator Peterson, if there's a amendment or something, I'm not seeing what you're saying. What I see is Supreme Court should have discretion to grant a certificate without examination.
Oh, no, that's the original bill, the substitute.
Okay, well, I don't have the substitute in front of me.
Mr. Chairman, the substitute is posted on LIS under Senate Bill 1234.
All right. Well, let me...
And the substitute simply says that if he's been licensed as an attorney or or a barrister in a foreign country obtained an LLM in the United States and been admitted to practice law in any other state, he can just take the bar. I don't know what I don't know what the Supreme Court's view is.
Supreme Court on the line. I talked to them over the weekend.
So you have to have an LLM from an accredited law school in the United States, right?
Yes, sir. That's one of the 3 criteria.
So you got,
Mr. Chairman?
Which more, after you get your JD, you get your LLM.
Well, Mr. Chair, you're missing the point. There is no JD. These are people that got a foreign degree or they're licensed to practice in a foreign country. They come to the U.S., get an LLM, and they have a license in another state.
So they come to this country to get an LLM. So you have to have an LLM in this country.
Yes, sir.
Okay.
I'm not trying to get the law schools out of it. They're still going to get paid, okay?
Mr. Chairman?
Yeah, Senator Morrissey.
First of all, yeah, I would agree. My last description, despicable, that went too far. So I withdraw that. But I would ask the patron, is there still a requirement of pro hoc vici appearances in the Commonwealth?
No. When I talked with Ms. Poston, she thought that was, first of all, it put sort of too much of an advantage to those of us that do litigation. So that's all out. That was the original bill. That was based on my conversations with the bar.
So, Senator Peterson, every other state, people can practice.
I'm not saying every other state. I'm just saying that this is one of the outliers in that people that don't have an the ABA degree can't even sit for the bar, even if they're licensed in other states, even if they've been practicing in other countries.
So, but your substitute says you're a barrister or the equivalent in a foreign country, you obtain an LLM here in this country, and you're admitted to practice law before one of the states of this country.
Right.
Okay, all 3 of those. All right. Okay. Is there any discussion, any further discussion? Is there a motion?
Mr. Chair?
Yeah, Senator, go ahead. Mm-hmm.
Mr. Chair, Alyssa Padden with the Supreme Court is here in the Zoom room.
Okay, thank you.
Good morning, Mr. Chairman. Can you hear me?
Yeah, yes, please, go ahead.
I was just responding to the questions from the committee about the position of the court. We have no position on the legislation.
Okay.
There you go.
Is anybody opposed to it? Okay, is there a motion?
Second.
Then moved and second to report to the substitute. It does not have to go to finance. All in favor of the substitute being reported, vote aye. All opposed, vote no.
Senator Norman, how do you wish to vote?
I vote aye. Senator Norman, aye.
Check. Ayes 15, no 0.
Good. The substitute is reported. Thank you. Okay, the next bill is Senator Donovan. Is Senator Donovan here? Okay, Senate Bill 1323. This was heard in Commerce and Labor and re-referred to the Courts of Justice. I think because of the liability issues.
Thank you, Mr. Chairman and members of the committee. I'll start by saying there is a substitute or an amendment.
Okay.
Which
Mr.
strikes
Chairman.
the language that was of concern to Commerce and Labor in Section D.
Mr. Chairman, the line amendment is on page 2, starting on line 78, strike lines 78 through 82.
Mr. Chairman, I move that amendment.
Is there a second? All in favor of the motion to adopt the line amendment, say aye.
Mr. Chairman, and I think we talked about this in this committee, maybe not, but I think that was the language that Senator Servell had some considerable concern about. I discussed it with the patron that striking that hopefully would address Senator Servell's concerns in that regard.
Okay, let's make sure we get is line what? Line 78?
Yes, Mr. Chairman. So strike subsection D, lines 78 through 82.
Okay. All in favor of the line amendment being struck, vote aye, say aye.
Aye.
All opposed, no. Okay, we have the motion, the bill before us. Okay, Senator Donovan.
Thank you, Mr. Chairman. And to make this brief, this seeks to address the jobs of 59 million Americans who earned some of their income over these past strange 12 months from independent work. Last year, we passed 3 pieces of legislation that defined and sought to ensure that full-time employees were not misclassified as contract employees. And, Mr. Chairman, contract employees want similar protections to ensure that they're not forced into a situation where they might have to be full-time employees with benefits. And, Mr. Chairman, in a nutshell, that is the bill.
Any questions? I have a question, Senator. My concern for the bill is the liability, contract liability, tort liability. There's a huge difference between an independent contractor and an employee. Corporations operate through their employees, and they can be held liable under the legal theory of responding out superior because they're employees. Independent contractors are not liable. They cannot, whatever they do that's maybe wrong, contract violation, tort, or whatever, the person hiring the independent contractor is not responsible. That's the problem. It's a huge, huge issue as far as I'm concerned, and I'm going to vote against the bill for that reason. It's like if I have a guy mowing my lawn, and he rents the lawnmower, I'm not responsible for that. He's an independent contractor. But if I'm a lawn company and I'm hiring people to go out and they rent a lawnmower and they don't pay it, then the employer is responsible, not just the employee. So there's a huge difference between independent contractors and employees. And what is the reason for the bill? I can't figure out why you want the bill.
Mr. Chairman?
The law is very clear in terms of case law as to what an independent contractor is and what an employee is. Yeah, Senator Openshain.
It would seem that the chair would like it to be a different rule for others than for himself. I'm not sure that I see the difference.
Mr. Chair.
Yeah, Senator Peterson.
And I think, let me speak a little bit from personal experience, and I appreciate this bill being brought, and I appreciate having this discussion. There is so much case law out there, both at the federal and state level, on what an independent contractor is. You have judges that have written 40-page opinions. I had a case in federal court that, cost millions of dollars and a lot of money, and turned on the issue of what's an independent contractor, and is now going to be up in the Fourth Circuit. So if for us to just sort of rewrite those rules and principles in about 10 minutes is a little bit problematic to me, and Lord knows I don't defer to anybody in my affection for Senator Donovan, but I just don't think this is the right venue to do that.
Mr. Chairman.
Okay, Senator Turville.
Thank you, Mr. Chairman. So, obviously I think this, I'm not exactly sure precisely what the intent of the bill is. I get that some people feel like there might be some confusion about what I think is well-settled common law, but I know there's also a lot of discussions that are currently ongoing about how we're going to provide benefits to people who choose to operate in an independent contractor setting. So, for example, people in this gig economy that hop around and work for multiple services at once, working for one by themselves, they might not have a benefit package, but collectively with the income they make from all of them, it might be enough to pay. And I know that's an ongoing discussion we're having about how to try and get benefits to people that operate in an independent contractor setting. And so, it seems to me, I know we're having, I think, some conversations at the HERC on this, the Health Insurance Reform Commission, to try and figure out if there's ways we can try and provide benefits to people in an independent contractor setting. There's been lots of proposals about that, and it seems to me that might be a place to at least have some discussion about, I think, part of what this bill is motivated by, maybe not everything, but at least part of it. And so it seems to me that, Mr. Chairman, maybe when we gently put this bill aside and tell the HERC to take a look at benefit programs for independent contractors. I think that might be the...
Mr. Chairman, if I could...
Yeah, Senator Donovan, go ahead.
Thank you. Mr. Chairman, just to respond to a couple of the comments that have been made, despite the case law there was the chaos we saw ensue in California with AB 5. And I think independent contractors are seeking to have the same shored up and a sense of confidence that they have protections in pursuing. I don't know that they're as interested in the benefits as perhaps legislators are for them. I think they want the freedom to be able to choose where they work, how they work, when they work, and to be their own boss. It's an entrepreneurial situation in many cases, and they're underconfident about the case law protecting those rights, as evidenced in California with the chaos that we saw play out there. I know that I have at least one person to speak to the bill who has far more legal expertise than I do, and was involved in drafting the bill, and I'd ask that the committee hear him speak.
All right, yeah, let's go ahead and who'd you ask to speak for the bill?
I believe Mr. Ben Knotts, and I don't know if there are others or not, Mr. Chairman.
Okay, Mr. Knotts. Go ahead, Benjamin Knotts.
Thank you, Mr. Chairman. Ben Knotts with Americans for Prosperity. We've been working in a number of states, and we've identified that a lot of debate over mandated benefits can end up into reclassification actions by the legislature. And what happened is a lot of these people that weren't interested in being reclassified found themselves thrown into it. And so then you had a Christmas tree of exemptions that are a result. And so as the federal government right now debates finding a third way to define workers, what this bill seeks to do is just explicitly define a Virginia code to make sure it's clear that Virginia sees these ways of identifying it. So those folks that are practicing in these different spaces, whether it's a gig worker or whatever, any sort of independent contractor, they see in the code their job is protected. It's explicit in the code, and so there's confidence there. And so this has been an issue. The federal government is debating, again, a third way. But regardless of what they do, the outcome is to provide clarity in the code that those jobs aren't going away.
Okay, any questions? Okay, anybody else would like to have a different view that's out there?
Mark Dix, please go ahead.
Mark Dix.
Good morning, Mr. Chair, members of the committee. Mark Dix on behalf of the Virginia Trial Lawyers Association, and we oppose the bill for the reasons that Senators Peterson and Servell previously mentioned. But principally, this supplants the Virginia Workers' Comp Commission's purview of these issues. There's a well-developed body of case law that deals with this particular issue, and we shouldn't be taking that away from the commission to be able to determine. Instead, what it does is it shifts to the employer to dictate by a contract of adhesion, certainly in paragraph 1, as to how their employees or their independent contractors are going to be treated. It's going to push them all into the independent contractor setting. So we also have a concern that it may bleed through over to respondeat superior. Granted, it deals with workers, the classification of workers in this title of the code, but we're worried that a judge may apply this outside the context and into ordinary tort cases. So for those reasons, Mr. Chair, we oppose the bill. Thank you.
Okay, thank you. Anybody else like to speak on the bill? Yeah, Jason Parker.
Thank you, Mr. Chairman. Thank you, committee. We oppose this bill as a Virginia State Building Construction Trades Council. We don't understand how taking workers' rights and protections protect workers. That just seems kind of bizarre to us. The path to making yourself whole when you're misclassified as an independent contractor is far more prevalent than independent contractors for some reason not wanting to be full-time or part-time employees, as by the IRS litmus test that they have. Thank you.
Okay, thank you. Who else would like to speak, one way or the other?
Mr. Chairman, this is Dale Bennett with the Virginia Trucking Association. Independent contractors are a key part of what we do to serve Virginia's logistics chain, especially at the Port of Virginia. And we think this bill provides some clarity and helps avoid some of the potential issues we could face if we end up with a situation like they've had in California. Thank you.
Anybody else want to speak, one way or the other?
At this time, no other hands are raised, Mr. Chair.
Mr. Chairman, I'd just like a quick follow-up.
Yeah, go ahead. Go ahead.
I'll just assert in response to some of the comments I heard that we took protections to ensure that there was not misclassification last year of full-time employees as contract employees. And I would assert that if there was more interest in the independent contractor arena in having full-time benefited positions, we would not have seen the response we saw in California, which overturned the decision of the legislature to ensure that independent contractors had the freedom to make the choices they wanted to.
You understand, as I heard Uber says their drivers are independent contractors, and a big lawsuit about it, and the court ruled they were not independent contractors. Am I right about that?
I couldn't hear what you said, Mr.
Yeah,
Chairman.
Uber
Right.
claimed that all their drivers were independent contractors. And I read that there was a lawsuit, I believe, and the court ruled against them.
Mr. Chairman, I can't speak
Okay,
for
all
Uber
right.
or on that lawsuit.
Okay.
Mr. Chair?
There was a referendum, and the referendum will essentially...
Mr. Chair, I'm sorry, Jennifer.
Okay, all right. Senator,
Chair?
Yeah, Senator Boysko.
Mr. Chair, has the Attorney General's office weighed in on this bill?
Oh, that would be nice.
Has the AG's office said anything?
They don't do this.
I'm not surprised. Okay. Is there, if everybody's spoken, is there a motion?
Mr. Chairman?
Yeah, Senator Bill.
Serval. Mr. Chairman, I've moved the PBI of the bill with a letter from you to the HERC, asking the HERC to look at benefits for independent contractors. I think that's what we need to do.
Asking who?
Sorry?
Who? Asking who?
The HERC, Health Insurance Reform Commission, that I sit on with Senator Barker.
Okay.
Mr.
Not everybody understands what these acronyms mean. H-U-R-T, is that what it is?
HIRC.
It was written up H-U-R-T. Okay, Health Insurance Reform Commission. Okay, is there...
Second.
Any discussion? All in favor of the motion to pass the bill by and definitely with a letter to the Health Insurance Reform Commission, vote aye. All opposed, vote no.
Senator Norman, how do you wish to vote?
Senator Norman votes aye. Senator Norman votes aye.
Check. Ayes 10, noes 5.
10 to 5, the bill is passed by indefinitely with a letter to the Health Insurance Reform Commission. Thank you, Senator Donovan. Okay.
Mr. Chairman,
Yes.
you still have two bills that are in block one that would need to go to finance. I just wanted to remind you.
Okay, what's the next one?
Senator Morrissey has Senate Bill 1264 and Senator Serraville has Senate Bill 1440.
Okay, trying to get people who are not here. Okay. Senator Morrissey, 1264. Senator Morrissey, 1264. Okay.
Thank you, Mr. Chairman. This is not going to take a long time. This bill simply says that it provides that a person against whom an emergency or preliminary protective order has been issued, and then it is subsequently, the victim doesn't show up, it is dismissed by the judge after a hearing, that those records can be expunged. Let me explain. Right now, anybody can go to a magistrate and get an emergency protective order. I'm not being cheeky when I say the following. Senator Chase could go today and get an emergency protective order against Senator Obenshain by simply saying, I fear bodily injury. It's issued in 99.9% of the cases. What happens is sometimes the victim doesn't show up, other times it may be heard by the judge and dismissed as entirely groundless. Right now, or it could just expire. The emergency protective order expires after 72 hours. If that were the case, and it is completely baseless, completely meritless, you can't get it expunged. That's the genesis of this bill. With that said, I'm going to make a motion because of some comments from other folks. If you want, I will take a question, but I'm going to have a motion to pass it by and refer it to the Crime Commission. But I'm happy to address a question if you had it, Senator.
Any questions to Senator Morrissey about Senate Bill 1264? Okay, no questions. You want this to go to the Crime Commission?
I do, and if it helps, Mr. Chairman, I will draft a letter for your signature to send over to the Crime Commission.
Okay, the motion then is to pass the bill by indefinitely with a letter to the Crime Commission to study the issue. Is that correct? All right, is there a second to that motion? All right, all in favor of the motion to pass it by indefinitely with a letter to the Crime Commission, vote aye.
Senator Norman, how do you wish to vote?
Senator Norman votes aye.
Ayes 15, no 0.
Okay. Kristen, is there any other bill that needs to go to the Finance Committee? Senator?
Yes, Senate Bill 1440, Senator Sarvel's
Okay,
bill.
Senate Bill 1440 of Senator Searle.
Thank you, Mr. Chairman. Senate Bill 1440 evolved out of the discussion that we had during the special session about civil liability for law enforcement officers who violate statutes and rules. As you all remember, there was a discussion, a bill that came over from the House, which we talked about, which our committee found was too broad the way it was worded. And so this is an alternate approach. It's an approach that I think many of us discussed. And basically what it says is that any law enforcement officer who violates the statutes that we passed during the special session in the new chapter on use of force would be civilly liable for any personal injuries that somebody receives as a result of that violation. If you all remember, in that article, we passed a provision prohibiting chokeholds unless an officer's life's at risk. We passed a provision prohibiting shooting into a moving motor vehicle unless somebody's life is at risk. We required some other standards with regard to the use of deadly force. And we also passed an article relating to an officer's duty to intervene in the event excessive force is used. Each of those statutes has, I guess, standards within them, whether it's a reasonableness standard in some situations or there's certain exceptions that you can prove, for example, to use a chokehold, like if your life is at risk.
Mr. Chairman.
Can I finish and then I'll take questions?
Senator Searle, finish.
One of the other big concerns that we heard from law enforcement about the bill last year and some of the bills that have been talked about around the country is law enforcement officers concerned about personal liability, potentially having their home or their assets at risk. This bill specifically requires a locality to indemnify a law enforcement officer for any kind of damages that were to result. So the locality would have to pay. And in my experience, that's pretty much what always happens anyway, although I've heard some localities grumbling about this. But I can't remember the last time I've heard, if ever, about a law enforcement officer having a judgment taken against them in a 1983 action and the locality didn't pay the judgment. But this makes explicit in the bill that the locality will pay for the judgment, even though the police officer can be held liable also. So the only way a law enforcement officer could have to pay something is if the locality doesn't have any money. So that's basically what the bill does. I think it's an approach that is much more narrow. It focuses on what most people care about, which is police officers, law enforcement officers, breaking rules in ways that hurt people physically. So that's basically what it's focused on, and it's basically a sovereign immunity waiver. Mr. Chairman, I'm happy to take any questions.
Okay,
Chairman.
Senator Sasslaw.
Did I hear you right that if the locality didn't have the money, then the officer would have to come up with it?
Well, or if their insurance company didn't have any money. Most localities are insured by the Virginia Municipal League Insurance, and I can't speak for all 400 some localities and whatever, and I can't remember that I've ever heard of a locality in Virginia never not paying some sort of judgment. But theoretically, that's theoretically possible. I think it's highly unlikely.
Okay. Any other questions of the
Mr. Chair?
Yeah, Senator Morsi.
Senator Searle, last night during dinner, I probably had a half-hour conversation with two of the police chiefs in my jurisdiction, Hopewell and Petersburg. Can you address, because you mentioned specifically chokeholds in your summary, it's not just chokeholds, but it's other behavior by a police officer that causes injury. Is that correct?
Yes, Mr. Chairman, it's not the law yet. It's not the law until March the 1st.
Right.
But it's actions that are covered by it's the new Chapter 7.1 and Title 19.2. And 19.283.4 prohibits the use of an next restraint. B prohibits the use of a firearm into a moving motor vehicle. Subsection C has to do with kinetic weapons. Then 83.5, the next code section, has to do with deadly force, and it has standards for the use of deadly force, and then a set of standards by which deadly force is evaluated by, and then Section 19.283.6 has to do with a law enforcement officer's duty to intervene in cases of excessive force. And then those statutes that are there right now are per se grounds for decertification. And I would submit that if somebody were to be sued for a 1983 violation, these statutes that we adopted would waive qualified immunity in a 1983 action because they are clearly established rules that are in the code. And so, from my perspective, this bill doesn't really do a whole lot to change the law of civil liability, except that it requires the locality to indemnify the officer. I really don't think it is really a huge change.
Mr. Chair.
Can I just have one follow-up question, very brief?
Senator Morrissey.
So the violations that you just mentioned, the untoward conduct of a police officer, that was the total list of behavior, is that correct?
Right.
So final. So that this would not allow an individual who claims that an officer pushed him or shoved him to bring that type of action. Is that right?
Mr. Chairman, the only time I think pushing or shoving could fall into it is if that somehow fell into the excessive force provisions under 19.283.6, and a push or a shove probably wouldn't get you there, is my guess.
All right, thank you.
Okay, anybody else has questions?
Obenchain.
Patron?
Obenchain.
Mr. Chairman.
Obenchain, yeah.
All right, a couple of things. I mean, number one, just want you all to realize what this is doing. This is a repeal of qualified immunity, number one. Number two, right now, with qualified immunity and with insurance as it is, if you've got a police officer who engages in intentional misconduct, hurt somebody intentionally, or something that is clearly unconstitutional, that police officer has personal liability for it. That's a disincentive for that police officer to act intentionally or in clear violation of somebody's constitutional rights. That police officer is insured under a policy issued to the city or county, typically for $1 million. If the verdict is $10 million, the officer has personal liability for it. Under this bill, the officer has no liability for any of that conduct. Okay? So he does this with impunity, clear violation of constitutional rights, knowing that the city or county is liable for the damages. And it can be $10 million, not $1 million as is really the effective cap right now, unless the city or county did something clearly wrong. So, this is also adding attorney's fees and other damages as well. So, this is turning the American rule on its head with respect to these actions. This is creating a safe harbor for unconstitutional conduct by police officers, and I know that that is not what the patron is intending to do. I want to make sure that police officers are protected for reasonable actions that they take, and I think this would protect them, but it imposes a significant liability on those local governments as well.
Mr. Chairman.
Okay, yes, Senator Sherrill.
Thank you. So let me try and be a little clearer about some things. Qualified immunity is not blanket immunity for police officers. I think there's a misapprehension in the public about what qualified immunity really is. Qualified immunity does not apply when somebody's constitutional rights are violated by a government officer if those rules are clearly established in the law. So if the rules are clearly established in the law, there's no qualified immunity. In last session, special session, we adopted a whole series of clear rules. So the effect of adopting those clear rules was to abrogate qualified immunity for violation of those rules. Okay? So this bill just simply reconfirms that in state court, you can bring an action, civil action, for violating those rules, just like you could on a 1983 action. And additionally, in a 1983 action, you can already recover attorney's fees under 42 U.S.C. 1988. This confirms the same thing. So the only difference I would submit is Senator Obenshain is correct about the indemnity piece. And perhaps there ought to be language in here about some kind of intentional, willful misconduct not being subject to indemnity. But I would also just note, in anticipation of some of the things that might be said by people in the public, the reason I phrased it as primary employer is because sometimes police officers are subbed out, I guess, the fairest way to say it, to like banks or events or whatever, and they make overtime or get paid to wear a uniform and stand security at places. And there was some concern the way my bill was originally drafted that it would disincentivize those third parties from hiring police officers. And so I put in this language about any primary employer that employs or contracts services of a law enforcement officer, yada, 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 with or without pay, shall be liable when the violation occurred within the ordinary course of the employer's business. So, I mean, if the senator would like to make an amendment to carve out willful, malicious, intentional conduct from that, I think that there might be a discussion to be had there. That's one of the nuances of this that gets kind of complicated.
We have people here waiting to speak. Let me clarify one thing. Qualified immunity is case law in the federal system only. It has to do with qualified immunity when a law enforcement officer is sued under 42 United States Code, Section 1983. That's all it is a federal case law with regard to federal lawsuits. It doesn't apply to the state at all. Now, several people would like to speak, I believe.
Mr. Chair, before we get started, could I move that amendment that the patron suggested?
All right, the amendment is to say the amendment again. Where's the amendment? Line amendment?
You asking me, Mr. Chairman?
Yes, somebody.
I think it would probably go in line 24, and Charles could probably write this better than I could, but it would say something like, provided that there be no liability for any act that was committed willfully, maliciously, and intentionally.
All right, that's a concept. I'm sure Charles can come up with some language.
Can I speak to that?
Yeah, but go ahead, Senator Obenshain.
So here is the rub, is that any good attorney can avoid that. I mean, if I'm trying to sue Officer A who committed an intentional act, and I want to make sure that I can recover, all I have to do is avoid alleging that the act was intentional. And it's all a matter of pleading. And what we're doing is simply creating a roadmap for how to pursue this without pleading yourself out of coverage. I mean, it's what we do in civil cases, other civil cases all the time, is you don't ever want to allege that somebody did something that's not covered by an insurance policy. So we're just creating the roadmap for how to do that. So.
Okay, everybody understand? What he's saying is, if you put this intentional in, then there's a question of insurance coverage. Okay? But you want the language, where would it go? Which line?
Line 24, Mr. Chairman. At the end of line 24.
When such violation occurred within the ordinary course of the employer's business and was done intentionally?
No. I said provided that there shall be no liability for any act that was performed willfully.
Mr. Chairman, I would say provided that such officer did not act willfully, intentionally, or maliciously.
There you go.
Oh, didn't, okay, did not. Okay, so you keep the insurance in.
So, Mr. Chairman, and I hate to ask one more question, But what if the locality knew that the officer had a history of acting willfully, intentionally, and maliciously? Shouldn't the locality have liability then?
Mr. Chair. Evidentiary issues, yeah. Senator Sherrill.
Peterson.
Peterson, okay. Senator Peterson.
Mr. Chair, I know we could spend hours on this, and I'm certain you have speakers, and I'm looking forward to hearing from them. But once we've done that, I'm going to make a motion to have this referred to my Civil Laws Subcommittee, where and I'm at that point going to make a motion that we're going to sort of take this by and talk about it. I just don't want to see us rushing through this, needless to say, but that will be a motion I will make.
Okay. Right now we have this proviso on line 24, provided that the officer did not act intentionally, willfully, and whatever. Is that right? Is that the motion? Provided?
So moved. Yes.
Yeah, Kristen, okay. All in favor of the line amendment, say aye. Aye. All opposed, no. Motion carries. Okay. Now, there are several people who would like to speak, I'm sure. Who would like to speak first? Wayne Huggins?
Good morning, Mr. Chairman. Thank you for affording me the opportunity to speak. I could talk about this at length for longer than you want me to. And we do appreciate Senator Servell giving us the opportunity to review this. For the variety of legal reasons that have already been stated, we absolutely oppose this. But I want to talk about the human element rather than the legal element. Law enforcement widely views this as yet another assault on our profession. It's impacting enormously our already low morale. In fact, I was recently told by a member of your committee that the police department, the law enforcement agency in their jurisdiction has basically backed off. In fact, they're being referred to as parking lot security because they are not out enforcing the law. They are afraid. Their morale is low. And even after having just graduated a basic academy class, we still have over 300 vacancies. So the question becomes, why do we want to keep throwing these impediments up when clearly, in our opinion, this bill provides absolutely nothing that is not already available to enterprising defense lawyers who want to sue law enforcement? So for those reasons and many, many more that I could cite, we are absolutely opposed to this. Thank you.
Yeah, thank you, Wayne. Next, who would like to speak? John Jones?
Thank you, Mr. Chairman. I'm John Jones, representing the Virginia Sheriff's Association. I'm not going to repeat what Wayne said. We endorse that. I would say this. Our turnover rates have substantially increased in the last year. Our turnover rates are hovering around 35% in some of the sheriff's offices and even more in some. It's hard to find deputy sheriffs to work, and the starting state salary is about $34,475. I've had sheriff after sheriff after sheriff and deputy after deputy say, if this qualified immunity bill passes, they're out of here. They're not going to work with everything going on and be subjected to more suits than we've got. We already can be sued. We have been sued. When we're wrong, we get sued. When we lose, this will open the door for frivolous suits, we think. So for that reason, Mr. Chairman, I would clarify one thing that's been said. The local governments do not provide liability insurance for the sheriffs. There's a $1.5 million, it's not actually a policy, but it's provided by the Commonwealth through Risk Management or Virginia Risk Policy. So we're very much opposed. I'm representing 118 of the 123 sheriffs and 9,000 deputies, Mr. Chairman. Thank you very much.
Okay, thank you. Next, who would like to speak?
Mark Segal, please go ahead.
Thank you. Can you hear me, Mr. Chairman? Mr. Chairman, can you hear me?
We can hear you.
Thank you very much. The only thing that I'm going to say when it comes to the legality of this is that 20-something years ago in the city of Richmond, there's a case, Mark Snoop, who was a police officer, who, in my opinion, got a very sympathetic jury to the opposite of police department's views, and he received a $400,000 punitive judgment. He ended up having a mental breakdown, essentially, and losing his job. job. But what I want to talk about is another part of the human element of what's going on here. Since June 29th in Central Virginia, particularly on the Richmond Police Department, the Henrico Police Department, the Chesterfield Police Departments, and I represent Hanover County, though, and we've been on standby to assist them. These have been unprecedented times since June 29th. Our police officers in this area have endured assault, gunshots, objects thrown at them, their cars surrounded, bricks hit at their car and their heads. Officers received endless complaints, the destruction of the city of Richmond, fires, businesses burned down and closed in the middle of COVID, and officers with COVID. Now we're talking about officers having the duty to act or intervene when we're scared to intervene because of the way the laws are going. Law enforcement was never consulted, to the best of my knowledge or anybody else's, to provide solutions or work with anybody to come up with solutions. Many LEOs are working without community support, particularly in urban areas. And the destructive political rhetoric that we hear. Listen, we are here 24/7, 365. We will leave opening up our Christmas presents with our children to assist anybody. Since May 25th, the date of Minnesota's death of George Floyd, officers in Virginia have continued to answer calls for service, providing CPR, Narcan, processing homicide scenes, working fatal crashes, catching robbers and burglars, arsonists and rapists. Virginia LEOs do not deserve punitive actions to open the floodgates and allow frivolous lawsuits. And lastly, I ask every member of the committee, would you want to become a police officer, or would you want your child to become a police officer now? And if that answer is no, we really need to re-examine where we're going. Thank you, Mr. Chairman.
Thank you. Maggie DeBoard. Maggie DeBoard.
Good morning, Chairman. Thank you. I'm going to be very brief and so I can give my other chiefs time to speak as well. The Virginia chiefs adamantly opposes this bill. I do not want to hit the points that our other LEOs have made at this point, but I will say this. There's a big difference between the job we do and those who carry liability insurance, like doctors and defense attorneys and others. We can't walk away. We cannot choose not to answer a call despite the personal risk or liability that we face every day. We have to handle those calls. And there's a huge concern with the passage of this bill that anytime we put our hands on somebody and somebody gets hurt, and that is bound to happen in the bad encounters that we typically have, we can't avoid that all the time. We can't do our jobs effectively with unnecessary lawsuits hanging over our head or an officer hesitating or worrying about what might happen in an encounter. Proactive policing, where it is needed most in our jurisdictions, is largely going to disappear with this bill. And as has already been said, it is disappearing and has been disappearing over the past year due to the anti-police sentiment and rhetoric that's been passed. We do have a mental health crisis in our profession, and it is growing every day. The passage of this bill will only exacerbate that. Lastly, I do want to say that you did some very good things by passing some bills in the special session that have increased accountability on not only us as law enforcement officers, but on our leaders. Let these new laws do what they're intended to do. It will hold us more accountable while still providing us the legal protections that we not only should have, and I would argue that LEOs are the exact people in that code that need to have those protections due to the quick decisions they make, but also the legal protections that we deserve to have for doing the job that it is very difficult and is largely unwanted by the general public. Thank you.
Okay, thank you very much. Ryan Zudema.
Thank you, Mr. Chairman. I'm Ryan Zuma. I'm Chief of Police in Lynchburg, and appreciate the time. I won't repeat like Chief DeBoard said everything else, but I base my opposition to this on 24 years of law enforcement experience here in this Commonwealth. This bill would be detrimental to law enforcement officers, to departments, to local governments, and the communities we serve. Bottom line, this is a recruitment and retention issue 100%. For some perspective, we have seen in Lynchburg in the last 10 years an 83% decrease in applications to become police officers. We've seen over a 30% decrease in just the last calendar year from 2019 to 2020. We believe that this bill would be passed, it would have a ripple effect through our communities. We think crime would go up because, as you've heard, proactive policing already is going down, and this would decimate proactive policing. This is going to drive away the good men and women who are already in law enforcement now, and it's going to discourage new officers from coming into law enforcement at a time when we need new officers more than anything to come out in our communities, engage with our communities, partner with our communities and support some of the change that we are all seeking, I think. Obviously, it's been said, but officers do not have absolute immunity. They can be and are held liable every time they step out there if they're violating a clearly established constitutional right. And we just see this as a bill that is going to be detrimental to law enforcement overall. It's going to be extremely costly to localities. It's going to not allow us to do the job that we need to do in the community, again, now more than ever. It's going to create frivolous lawsuits in our justice system that is already so far behind keeping up with cases because of COVID things. So we're 100% against this bill. We would ask that you not vote in favor of it. Qualified immunity is certainly not there to protect against criminal conduct. We hold our people accountable when they step out of the line. I thank you for your time.
Okay, thank you. Next, anybody else want to speak?
John Clare, please unmute and go ahead.
Thank you, Mr. Chairman. My name is John Clare. I'm the Chief of Police of the town of Marion, and I also represent the Virginia Association of Chiefs of Police, and I'm a third-generation police officer. I first want to say that I appreciate Senator Sorvel's categorical limitations compared to some of the more broadly worded language that we've seen in other bills. In a vacuum, these seem like reasonable limitations on immunity and a justifiable cause for action. And as a conscientious police officer, I empathize with that intent, but we don't live in a vacuum. In the last week, during Senator Reeves' requested language adjustment to the bills in 19283, language which to us seems somewhat nebulous and problematic, the response was that we don't want to change a bill before it goes into effect. We want to see how it turns out. I can tell you that no law enforcement officer wants to see how it turns out when they're held financially liable with almost limitless exposure. No reasonable person, especially a police officer, making decisions with very little information in very short time periods, can be held to a standard that evades legal definition, no matter how conscientious they may be. And if I could just end with this quote from the U.S. Supreme Court and paraphrase that says, "A policeman's lot is not so unhappy that he must choose between a dereliction charge if he doesn't act and financial damages if he does." If bills like this pass, the policeman's lot will in fact be that unhappy. And I would urge you to vote against the bill. Thank you very much for the time.
Thank you very much. Somebody else want to speak? Yeah, Ara, go ahead.
Good morning. My name is Ara Trambley, and I'm here speaking on behalf of VADA, the Virginia Association of Defense Attorneys, about concerns about this bill. First of all, we're not sure why the bill is necessary. Virginia has a common law battery action that's been used successfully to challenge police officers in deadly force cases. There was a very recent, very large verdict in Northern Virginia on a battery claim in a wrongful death case. There are established standards and common law defenses in a battery case. Sovereign immunity is not a defense to a battery claim, so we're not sure why this additional cause of action is necessary. Second, these new conduct standards that have not even gone into effect yet are different from established Fourth Amendment standards for use of deadly force. They're brand new. It's not clear to me that all the police departments and sheriff's offices have trained all their officers in these new standards, yet without knowing that these standards have gone into effect and the officers have been trained, this creates a cause of action for violating these standards. The way the standards are written right now, the remedy is use in a disciplinary proceeding. And if there are issues in the way police officers were trained by their departments in these new standards, that can be a factor that's dealt with in a disciplinary proceeding. But in this civil cause of action, it's not very clear what the standards are or how that kind of deficiency in training would affect the civil liability. The problem is this bill doesn't set up any standards or defenses to know how the case brought would turn out. I wanted to comment one thing about attorney's fees. It was stated by somebody that this is just like Section 1988 where there are attorney's fees, and it's actually not the same because under this bill, it's a one-sided bill. Attorney's fees are only available to a plaintiff who wins. If a police officer prevails in a case, he's not provided with the remedy of attorney's fees in this case. One thing I've heard from police officers is they're interpreting these bills as a requirement that they have to wait to be heard first before they can do anything. And one of the purposes of these standards was to get officers to report if they see another police officer acting in an inappropriate way. And I'm concerned if there's civil liability in addition to a disciplinary proceeding, that would have a chilling effect on police officers doing so. Thanks very much.
Good, thank you. Mark Dix, I believe.
Good morning, Mr. Chair, members of the committee. Mark Dix on behalf of the Virginia Trial Lawyers Association. We support the bill. With all due respect to my colleague from the VADA, this is about holding the employing agencies accountable in the most egregious cases. If we're going to prevent the next George Floyd, we have to have the employing agencies held liable in these type of situations, and consequently, we support the bill. Thank you.
Thank you. Dominique Martin, is that right?
Yes, that's correct. Thank you, Mr. Chair and members of the committee. We support, Dominique Martin, Policy Analyst, New Virginia Majority. We support this bill. We thank the patron for addressing the issue of qualified and sovereign immunity. We believe that these measures will increase accountability amongst our law enforcement. We know that qualified immunity has been subject to criticism by our top Supreme Court justices in the nation, saying that this can create precedents that say officers can act with impunity. We believe that people should be able to have their day in court if they believe that there has been some legitimate mistreatment given to them by law enforcement. And so we just hope that you guys can continue this discussion, pass this bill, and help improve relations between law enforcement and our community members by showing them and signaling to them that there is legitimate action for those who do feel mistreated by law enforcement. So thank you.
Okay, Phyllis Arico.
Thank you, Mr. Chair. Phyllis Arico from the Virginia Association of Counties. I associated our remarks with those of that are opposed to this bill. One of the reasons sovereign immunity and qualified immunity exist is that as one of the most important core functions of our communities, law enforcement has the largest exposure to litigation and other frivolous litigation. And so these reasonable immunities should not be eroded. I also just want to comment on, because this bill applies to the primary employer, which is going to be the localities, or the sheriff and the localities pay for their insurance, it's going to have a huge chilling effect on providing law enforcement to community and business and any kind of secondary type of law enforcement protection. Thank you.
Thank you. Anything else? Anybody else have anything you want to say? Michelle Gowdy?
Yeah, Michelle Gowdy with the Virginia Municipal League. I just want to thank the senator for being willing to talk to our group about this proposed legislation. We obviously would ask that you do not pass this legislation this year and that we continue to talk about it. You've heard all those reasons from our law enforcement and how strongly they feel about it and the effects on the localities and the financial effects especially. So we would ask that you oppose this bill this year, and we look forward to talking with the senator.
Okay.
Mr. Chair.
Yes, Senator Peterson.
Yeah, I'd like to make a motion, speak to the motion. I'm going to move that we pass this bill by, and I think the right place is to refer this to my subcommittee on civil laws. These do have to do with civil causes of action. And just as we're going to take a look at some other substantive issues, we can certainly take a look at this one. I tend to agree with the folks that said, you know, we passed such comprehensive criminal justice reform last summer, and those those laws are just now coming online, and we don't have really any standard of conduct. Plus, there are all sorts of indemnification issues and protection for folks, not just civilians who need to be protected, but also law enforcement personnel that are accused and have a right to defend themselves. So I just think that this bill needs a lot more time than the time we're giving it right now, so I would make that motion to PBI.
Mr. Chair.
Senator Deeds.
I would just ask Senator Peterson if he doesn't think that it makes more sense to create a joint subcommittee with the House Courts of Justice Committee to try to review this issue. My understanding is the House Courts of Justice Committee referred a similar bill to the Crime Commission, but of course, this is a civil action. Doesn't have anything to do with crime.
Right. I would be happy to work with the House. I'm not quite sure why they referred it to the Crime Commission. This has nothing to do with crime. This is not 18.2.
I would just hope that the chairman of this committee can reach out to the chairman of the House committee and see if you can get a joint subcommittee formed to review this issue.
Okay, but right now we have a bill to
Chairman.
pass the bill by indefinitely.
Mr. Chairman, question?
Yeah, Senator Morsi.
I'm inclined to support Senator Peterson's motion, but I do have a question of him. Because so many people have been involved and have spoken for and against this bill, your request that this bill be moved to civil sub is not a suggestion or even a leaning on your part that you believe that Senator Serville's bill has no merit. Is that correct?
No. In fact, ironically, I was going to draft a similar bill last summer, but found that it was a much more complicated subject than I was able to sort of put together last summer. The Civil Laws Subcommittee just simply reflects the fact it's a change to the civil law in terms of perhaps putting together a joint task force with the House. I think that makes all the sense in the world, and I'm happy to be part of that. Again, I think the Crime Commission is the wrong venue for this. This is a civil remedy. So at this point, my motion is to pass by, but with understanding we will study this issue spring, summer, in whatever venue the chairman chooses.
Okay. A lot of this has to do with sovereign immunity, by the way. Okay, so the motion has been made to pass the bill by indefinitely. All in favor of the motion, vote.
Mr. Chairman?
Yeah, Senator, who's this?
Right.
Oh, yeah, John.
Just a clarification. It's just to pass it by so that you can refer the bill to the Civil Law Subcommittee, is my understanding. Passing it by indefinitely will kill it.
Well, this is, I think the motion is to pass it by indefinitely. If in the future we want to send it to some other committee or something, we can do that too. Yeah. What is the motion? Motion to pass the bill by indefinitely, I think.
Mr. Chair, you could write a letter or you could create a joint subcommittee.
Mr. Chair, I'd like to ask that we do create some sort of a subcommittee. We pledged in the special session that we would deal with this issue, and I understand it's complicated. It's probably not going to get resolved today, but I do feel that it is our responsibility to take a really deep dive on it and address the challenges that people have brought forth.
Then the motion would be from Senator Peterson to refer the bill to his Civil Law Subcommittee.
Mr. Chair, may I ask a parliamentary inquiry?
The motion he made is pass the bill by indefinitely, which kills the bill, okay? Then
Wait, parliamentary
is
inquiry?
that the motion? What is the motion? Yes.
Parliamentary inquiry, Mr. Chair.
Yeah, Senator McClellan.
I'm trying to understand what John said. If the bill is PBI'd, can it be referred to a joint subcommittee, or does it need to just stay in the breast of the committee in order to be referred to a joint subcommittee?
PBI would kill the bill. One option I have put on the board is to PBI with letter.
Right. A letter to the Civil Law Subcommittee.
That's what I was seeking clarification on.
Okay.
Right, Mr. Chairman.
Yes, Senator Serval.
Right. Now, I don't think that a committee of this body has to officially have a bill in front of it in order to have a meeting and talk about concepts or talk about some words on a piece of paper that's in front of them. So, I mean, this process discussion is interesting, but I think that Senator Peterson's subcommittee can meet anytime after we're gone. We can put this piece of paper in front of us and we can talk about making changes to it for when we next gavel in.
The motion is to pass the bill by indefinitely. Is that correct?
Yes.
Is that your motion, Senator Peterson? Okay.
Yes, sir.
All in favor of the motion, vote aye. All opposed, vote no.
Senator Norman, how do you wish to vote? Ayes 9, noes 5.
Ayes 9, noes 5. The bill has been passed by indefinitely. That doesn't mean we can't have a Civil Law Subcommittee look at the piece of paper at some point. Okay? Everybody clear? Okay, thank you. Senator Sorrell, do you have another bill, Senator Sorrell? 1446? I'm sure this is going to be short too, right?
Your Honor, I have Senate Bill 1446. Senate Bill 1446 is a version of a bill that I put in last year. For some reason, got sent to Ed and Health and got sent off to have a discussion over the summer, which we had. And this is a recurring problem this body's been trying to deal with for a decade or more. Basically, the idea of the bill is to try and deal with treating medical doctors who refuse to speak to attorneys who are representing their patients. And so just to give you all a little bit of context, when somebody gets hurt, they go to an emergency room, they get treated, they come out, they end up going to some other doctors, et cetera. And if you end up deciding to try and make a personal injury claim about it, then you have to put in writing what the doctor's opinions are going to be to the other side. And in the medical records, the doctors often don't say, in the records, what they say is, the person came in, they had this problem, I treated it, it got fixed, whatever. But they don't often say what the cause of the problem was. In order to designate your opinions to the other side, when you're litigating, you got to tell them what the cause of the opinions are. And in order to do that, you have to talk to the doctor to make sure the doctor believes that the car accident or the slip or the fall or whatever it is that occurred caused the injury they're treating. If you put in there that the doctor believes they were caused and you didn't talk to the doctor, you can get sanctioned. The lawyer can get sanctioned in order to pay the other side's fees. And I would say the majority of doctors are happy to talk to you, especially if you pay them their hourly fee, which is usually like between $500 and $1,000 an hour in my experience. But there's some doctors and some health systems where the doctors just refuse to return phone calls. They say, I don't talk to lawyers, I'm not talking to you, I don't care if they were my patient or not, I'm not talking to you. And it creates a huge problem for everybody because, number one, the only way to present that evidence to a jury is you got to go out and spend $5,000, $10,000 and have a forensic examination done on your client. Or alternatively, you can subpoena the doctor to a deposition, which costs $2,000 to $5,000. And if the doctor gives testimony that is contrary to what your client needs, the defense will then subpoena the doctor to trial and just create a defense witness. And it creates a lot of time and expense and unnecessary wheel spinning. And so basically what the bill does is it says in paragraph 1 that the doctor has to have a fee schedule for talking on the phone, for doing depositions, for testifying at trial, and they have to provide the fee schedule upon request. Number 2, it says that if a lawyer or a life care planner would like to speak to the doctor, that they're required to set up a telephone conference, a phone call or something within 14 days of a request, provided that the lawyer has paid them in full, in advance, before the meeting, and that the doctor and the lawyer certify they're not investigating malpractice. Paragraph 3 basically says they have to give you deposition dates within 60 days of a request, and they have to attend the deposition provided they're paid in advance. And 4 has to do with them providing an estimate of what their future services are going to cost. And subsection B basically says that if there's an emergency and they have to cancel, that they can do that. Mr. Chairman, I also have 2 line amendments that Ms. Walsh has prepared.
Okay.
One
Chairman,
line amendment was requested by the Virginia Society of Orthopedic Surgeons, and that basically says that if the attorney cancels a meeting or a deposition within 14 days, that the fee is non-refundable. And the second provision is a new subsection C, which creates an enforcement remedy. It says that if a doctor doesn't comply with this statute, a court can fine them up to $1,000 per occurrence and award attorney's fees. And Ms. Walsh has actually prepared the amendments. Okay. I would move them.
Is there a second to the amendments, the line amendments? Is there a second?
Yes.
Okay, all right, it's been seconded. All in favor of the motion and the amendment to adopt the line amendment, say aye.
Aye.
All opposed? All right, motion carries.
Mr.
All right.
Chairman?
Senator Morrissey.
Scott, let me ask you this. With the exception of providing a fee schedule upon request set forth in paragraph 1, isn't all of this already being done? And I'm trying to understand the genesis of this bill because most doctors, every one of your items says pay them in advance for the telephone consult, for the deposition, et cetera. Are they not currently doing that?
No. So here's the problem. Some doctors just say, I don't talk to lawyers. My office doesn't talk to lawyers, or they say my system doesn't let me talk to lawyers, or, if you want me, take my deposition. That's all I'm doing. right? Which is the most expensive, clunky way for everybody involved to deal with it. So, and also, I just want to give you some context. This fight arose about 15 years ago, and it resulted in the Virginia Bar Association assembling a meeting of the trial lawyers and the defense counsel, whatever, and they published like a 10-page statement of principles of cooperation. And they hoped that by publishing this, everybody would just get along. You know what? It didn't work. And so about 5 years ago, I put out a request on a trial lawyer listserv and said, how many people have this problem? And actually, I wish I had brought in it. Almost 80% of the trial lawyers that responded said they have this problem, doctors not returning phone calls. And I have story after story after story. Then I reached out to Scott Johnson with the Medical Society and said to him, how can we fix this without doing a bill? He said, send me all the doctors' names who won't meet. I'll try and work with you. I sent him 20 names of doctors. He called each one of them up and said, stop refusing to meet with lawyers, stop refusing to meet with lawyers. I would say about 2/3 of them, maybe 3/4 of them stopped doing it, including a couple big practices. But there was a few of them that just said, I'm not doing it. I don't care what you say, make me. Okay? And so after playing ombudsman for like 2 years, I finally said, forget it. There's a couple of systems that just aren't ever going to change. We have to do legislation. And so by putting in this bill last year and having further conversations, I'm happy to say there's 1 or 2 systems that have now told me they're going to change their practice, but there's still multiple doctors out there that just will not speak to lawyers because they just say, I don't want to be bothered with it. And so this bill just creates a structure which makes it easier for everybody and saves everybody time and everybody money. And I really don't know what the concern could be by saying you have to have a phone call within 14 days of request and you have to arrange a deposition within 60 days of request and you're going to get paid in advance.
Right. Mr. Chairman, final question.
Yeah, Senator Morrissey.
I agree that it's practical, it's purposeful. What is the Medical Society saying?
Well,
they don't. This medical. I believe you'll hear from them in a second. And actually, this language was drafted by them, and we were within like 12 hours of a committee presentation. And I thought we had a deal, and then they withdrew it last year after some members started to complain to them. So they're officially opposed to it. But okay. I believe the orthopedic surgeons, who probably are at least half of the doctors that get involved in this, I think they're okay with the bill now as I've rewritten it.
All right.
All right, let's hear from the public, okay? Mark Dix.
Good morning, Mr. Chair, members of the committee. Mark Dix on behalf of the Virginia Trial Lawyers Association, and we support the bill. We thank Senator Surville for bringing this important piece of legislation forward. As Senator Surville mentioned, this is a problem for a number of our members, particularly in Northern Virginia, with doctors who just won't respond to letters, calls, or emails. And I know we probably could have titled this the Senator Surville and Scott Johnson Relief Act as well, because I know that they're tired of being ombudsmen for these types of issues. We believe this is narrowly tailored, and this provides a good rule book that we can all live by, because the principles of cooperation have just been utterly toothless. And we hope it'll be the pleasure of the body to pass the bill. Thank you.
Speaking of Scott Johnson, would you like to say something?
Good morning, Mr. Chairman. Scott Johnson, speaking as General Counsel for the Medical Society of Virginia. Senator Sorreville is correct. The Medical Society leadership voted to oppose this, and we have devoted a lot of time to talking and trying to work with him, and I appreciate his outreach. He didn't have to do that, and we don't take that for granted. But we are concerned that this bill basically would mean discussion stop, and there has been progress. We had a Zoom meeting on August the 5th where we got the stakeholders together, and there has been some progress, so it shows talking works. I would also point out this bill is not just written to physicians, it's written to all providers as well. And I would also note, I just saw the Second Amendment that Senator Sorreville mentioned there, and it's interesting that the penalty side of it is one-sided. You're putting the burden on the providers, but giving the attorneys a get-out-of-jail-free card if they don't comply with it. A number of groups also wanted to speak today, and Mr. Chairman, for the convenience of time, if I may just read the list of other associations who are opposed to this. The Virginia Association of Clinical Nurse, American College of Nurse Midwives, Acupuncture Society, Virginia Association of Behavioral Analysis, Virginia Midwives Alliance, Virginia Association of Physician Assistants, and the Virginia Nurses Association. Thank you.
Okay, thank you. Brent Rawlings.
Yes, Mr. Chair. Mr. Chair, members of the committee, Brent Rawlings from the Virginia Hospital and Healthcare Association. We are opposed to the legislation. Senator Surville is correct. We did have one meeting this summer, August 8th, I believe it was, during the pandemic. a few days before we entered into special session. And then soon on the heels of that had the largest surge in COVID-19 cases yet. So it's been a very busy summer. We have agreed to work on this. We do believe in facilitating cooperation between healthcare providers and attorneys. However, this legislation as introduced is very heavy-handed. That's a classic case of the bad apple spoiling it for the whole bunch. Primary concern here is the time frame for responses and the regimented approach that it includes. Also, the fee schedule component and the cost estimate requirements are unworkable. We've had several conversations in the General Assembly about fee estimates and the challenges involved, so it's not as simple as being suggested here. We essentially just think this creates a trump card for attorneys over the interests of patients. We're asking for a 14-day time frame. A lot of people can't get in to see their physician within 14 days, so we need to strike a balance here. We're willing to continue to have those conversations, and we hope that you will oppose this legislation.
Okay, thank you. Christopher West.
Thank you, Mr. Chairman, members of the committee. Christopher West with Kaiser Permanente. We're the nation's largest private integrated healthcare provider. I would just associate ourselves with remarks of Mr. Johnson and Mr. Rawlings as opposed to this legislation. This is just a heavy-handed mandate on our providers right now that are busy dealing with COVID and trying to defeat this pandemic. And so we would strongly want to continue our conversations to work out a resolution on the bill and hope that you would defeat it today.
Okay, is anybody else would like to speak? Okay, you've heard the bill.
Mr. Chairman.
Yes, Senator Serval.
This conversation's been going on for 15 years, and talking about another 12 months ain't going to do anything, okay? The doctors aren't going to agree to anything in the code, period. They don't want us telling them what to do. I don't understand what is so hard about saying 14 days to have a phone call and 60 days to set a deposition if you're going to get paid.
How about this?
Can I? Senator Peterson.
How about if they agree to participate, then they'll still be subject to the med-mal cap?
Okay. All right.
Voluntary registration.
Okay.
Mr. Chair.
All right, Senator Obenshain.
Yeah, let me just point out, I don't know where this is headed, but it is maybe a little bit more complicated, and I have sympathies on both sides, but I also know that part of the difficulty that some attorneys have in getting cooperation from certain healthcare providers is the way that the hospital they work for operates. Yeah. And, you know, I've had many issues with doctors who've told me, look, nothing personal, but the hospital that I work for, you know, they charge you these fees. They make me do this on my own time, and I get paid nothing for it. So it's a little bit my silent protest that I'm just not talking to lawyers. And it's not necessarily the doctor's fault. You know, it may be, you know, the hospital policy as well. So, I mean, it's a complicated, challenging, difficult issue.
Mr. Chairman.
Senator Morrissey.
A couple of comments and observations. I frequently find myself siding with the medical society and the hospitals in these matters, but I think I'm going to be hard-pressed to find a more common-sense piece of legislation in this session. First of all, with regard to one of the comments made that this is that ends the discussions. Senator Serval is right. The discussions have gone on long enough. There's no agreement. Number two, one of the people opposing it said this essentially gives the attorneys a get-out-of-jail card free. It does nothing of the sort. You read the legislation, they've got to schedule a phone call, they got to pay the doctor in advance, they got to schedule the essay deposition, they got to pay the doctor in advance, and third, the individual that referred to this being heavy-handed, this legislation is heavy-handed and defaulted to, we've got too many other things to do to deal with COVID. Nonsensical. I think the patron is correct. They have worked tirelessly to get to some type of agreement. Nothing has worked, and now it's time to do legislation, and I think it is fair, It's purposeful. It protects those patients who are trying to receive compensation and their attorneys simply can't get in touch with a non-cooperating doctor. So for that reason, I'm going to move to report.
I'll second that.
It's been moved and seconded to report. I'm hearing differently from the doctors and the hospitals that they're willing to continue working on this.
Too late.
And I don't think it is too late. If people were willing to work on it, I think they should. So I'm not going to support the bill. If there's anybody else want to send it to the Civil Law Subcommittee for the year, like we did the other bill? Not hearing anything. Okay. There's a motion to report the bill. Any further discussion? All in favor of the motion, vote aye.
Senator Norman, how do you vote?
That's a mix-up.
Senator Norman votes no.
Check. Ayes 8, noes 6, 1 abstention.
Wow, okay.
8 to 6 to 1. The bill is reported.
Thank you, Mr. Chairman.
Okay, now Senator Stewart, Senate Bill 1475. Okay, I can't hear you. Speak.
Sorry, Mr. Chairman. Mr. Chairman, there is a substitute, I believe, and I would move that substitute. But I don't know if it's available online yet.
Mr. Chairman, Charles here. I just posted the substitute, so it may take a second for it to load, but it should be available shortly.
Mr. Chairman, so Senate Bill 1475 actually is a bill that came from the chiefs of police. Senator Serval's worked on this. I've worked on it. I think Charles has worked on it, and Steve Benjamin. And the idea was to try to refine just a little bit the search warrant bill. There was some confusion. We had to carve out an exemption for the withdrawal of blood. There were people who were concerned about having to walk into a McDonald's in uniform and read a search warrant, etc. So if the substitute is up, if you all would look on page 85, that's where the substantive provisions begin. It now talks about a place of abode. To define this to a no-knock warrant where someone lives, and that's the whole purpose of it. There's a change of reasonably expected to reasonably designed to be heard by the occupants of the place of abode. You have to give them a copy of both the warrant and the affidavit. I'm sorry, I'm just going to go through these quickly. I think that's easier. You have to post it in the affidavit in a conspicuous place where you're searching. This now says versus daytime hours. It defines daytime hours of 8 a.m. to 5 p.m., but it says the initial entry of the abode. So one of the problems was if you do a warrant, we didn't know if you could stay there and finish the search or not. And I think that clarifies it up, or if you had to be concluded with the search during daytime hours. Those are the substantive changes. The original bill that I had dealt with the exclusionary rule. That has been removed from this substitute because I'm aware there were objections to that. I can tell this committee that the initial bill that was filed, I gave Senator Locke the courtesy of reviewing that bill before I filed it. She said she had no objection to that bill, and I think that the substitute she would object to even less if she had any objections. So I can't make a representation that she supports it because I've not shown her the substitute, but she was okay with the first bill and the substitutes even more narrowly defined. That, as we discussed then, that search warrant bill created some problems. And I'm not talking about the policy issue. The policy issue was made to do no-knock search warrants, but practically speaking and process-wise, there were some problems with that bill. This is an effort to try to fix the process so that the policy can be enacted without any serious repercussions, I guess is the way I would say it. So I'll try to answer any questions. I know Charles is on and Steve Benjamin is on, and I think I have to give them credit for the substitute, Mr. Chairman. And I thank Senator Serval for starting to present this the other evening when I had to leave a little bit early, but this is the finished product that I think we've all come up with.
Mr. Chairman. Thank you, Mr. Chairman. And I hope Senator Stanley will trust me now when I say that Senator Stewart said it was okay for me to present his bill, but
nope.
But Mr. Chairman, with regard to the edits in this bill, the issues that are raised in it are issues that were raised by the chiefs at sort of towards the very end of the special session process, and it was kind of too late in the process to get these tweaks in, which I think all of us thought were probably a good idea, and the governor neglected to make them in his amendments to the bill. But I think these changes, as refined, are all appropriate and clarify the bill. I don't think we want, a police officer to have to march in a uniform and yell at everybody at, Burger King, search warrant, start reading it to everybody sitting at their tables while eating their hamburger. So, or Impossible Whopper, if they're like me. But so, Mr. Chairman, I think the bill is a good idea. I don't know if there's any testimony. I'm sure the chiefs of police want to testify for it, but I think it's the product of a lot of good bipartisan work.
Mr. Chair, question for the patron. I want to direct your attention to that provision, at least on my hard copy. It's line 116. The law, you added the words, if the search warrant is executed in bad faith or if it is proven that the rights of an defendant were substantially prejudiced.
Mr. Chairman, he doesn't have the substitute. You need to go to LIS on your iPad and bring up the substitute. All that language was taken out that dealt with the exclusionary rule because there were some that objected to that.
I got it.
So we took that out.
I withdraw it.
Mr. Chairman.
Steve Benjamin.
The only lines I want to draw the committee's attention to are lines 104 through 106. Those lines, currently the preference is that if there's going to be a nighttime entry, a nighttime execution of a search warrant, the preference is that a judge authorize that entry. There is a default mechanism for a magistrate to do that. These lines 104 through 106 say that if the warrant is issued after 5 p.m., then a magistrate can do it. The officer does not even have to look for a judge. The problem with this language is that it permits an officer who wants to do a nighttime execution of a search warrant to always wait until after 5 o'clock. The current language doesn't even require that it be executed that night. For example, an officer could wait until 6 in the evening, not try to find a judge, go directly to a friendly magistrate and get a search warrant authorizing a nighttime entry, and then wait a week before executing that nighttime entry. And so this is the one section I think we had some discussion about and didn't fix it to everyone's satisfaction.
Mr. Chairman.
Senator Serval.
Thank you, Mr. Chairman. I would ask Mr. Benjamin or Charles or somebody, couldn't that problem be corrected if instead of it saying, unless the warrant was issued after 5 p.m., No, that wouldn't fix it.
No.
Never mind.
Okay, Senator Maggie DeBoard.
Thank you, Chairman. We appreciate the efforts to edit this. So this is significantly improved, and it does address many of the unintended consequences that happen with the special session. Our issue with the judge magistrate was this: we're not trying to set this up to a magistrate shop, because the magistrates right now have to determine the most important point for us, whether we even have probable cause to conduct that search warrant. The nighttime piece is a secondary piece, and we have zero objection to justifying the need to serve that after hours. We have no objection to that whatsoever. But the problem with the searching for the judge, especially in some parts of our state, sir, is that judges are not readily available all the time, especially after hours or different parts. This is certainly not an attempt to bypass a magistrate who's already ruling on that. We just want to have very quick access so that we can actually get search warrants without delay, especially in cases where time is of the essence. So that's why that was written in there. And the way it's written right now, it basically is looking at normal business hours. So 9 to 5, 8 to 5, a judge is typically available. But on the weekends and our holidays, they're still not available during those hours. We would need a system set up so that judges are readily on call for us and provide cell phone numbers so that we can access them at all times of the day or night. And if that's functional, that would be great. But we do have grave concerns about the delay that it could cause. The only other thing that I would bring up in here is the fact that we had also asked to have some language in there about the ability to serve a search warrant any time of day or night for any item that is already in our possession or control. For example, if we seize a cell phone or we seize a motor vehicle, that is already in our possession and control, and we would like to be able to serve those search warrants because that would not impact anybody in particular, no matter what time of day or night we serve those. It's kind of similar to the blood draw, and we'd love some consideration for that, but otherwise we greatly appreciate the edits that you've made to this bill so far.
Okay.
Mr. Chairman, it's Steve Benjamin.
Steve Benjamin, go ahead, Steve.
I would draw the chief's attention to the modifications, the edits that we made at line 96, so that the time limitation only applies to search warrants for the search for place of abode. So if an officer has something already in their possession, they can search it at any time, day or night.
Okay, thank you, Steve. I'm looking at it now as I just pulled it up myself, so that's great clarification. Thank you. That would address that issue. Thank you very much.
I agree.
Okay, yes.
Mr. Chairman, may I ask Steve Benjamin a question?
Yes, Senator
Stewart.
Stewart wants to speak to Senator Benjamin.
Steve,
I recognize what you're saying. I'd actually read that and had been thinking through it before you brought it up. But it seems to me there will be situations or circumstances that it would be necessary for them to get a warrant after 5 by a magistrate. And so my question to you is, why couldn't we insert in there somewhere, and you're a much better wordsmith than I am, to say when circumstances necessitate? I don't like an emergency standard. As you remember, this bill will be judged by the trier of fact after the fact. And so a judge can always determine whether or not circumstances necessitated getting it after 5.
Mr. Chairman, Senator Stewart, what might work would be if we required in that instance that the affidavit establish by specific facts that the search warrant reasonably could not be sought before 5 p.m. And let me pause. That's so you don't have officers who are deliberately waiting until after 5, and why it reasonably must be executed before 8 a.m. So if we required that in the affidavit, then that demonstrates why the officer couldn't obtain or seek the warrant before 5, and why it reasonably should be executed before daybreak.
So where would you, Mr. Chairman, where would you put that, Steve?
Mr. Chairman, Senator Stewart, that would go somewhere at line 10.
Well, does that
105? We would insert that language.
Steve, are we already covered in line 99 with your thought, where it says by particularized facts in an affidavit?
Somewhat. What we're not covering is what we're not covering with that language is that the search warrant could not be sought before 5. And the reason I included the additional language is to ensure that it's not an officer seeking a warrant after 5 and then delaying execution for several days. So that I wanted wording that would make it very clear that if the circumstances mean that the officer has to get the warrant after 5, that the circumstances include that the execution is reasonably necessary that same night. Otherwise, you have another day and you could go to a judge.
Okay, Senator Stewart.
Mr. Chairman, I don't want to drag this out, but it seems to me if on line 105 after subsection, we said when circumstances necessitate, that would cover it, because again, if you go down, this becomes judged by the trier of fact. And if they didn't need to get that warrant after 5 from a magistrate, then everything can be kicked out pursuant to the exclusionary rule. Senator Searle, are you paying attention?
Okay.
Not carefully enough.
I think that fixes it, Mr. Chairman.
Steve, you okay with that?
I don't feel strongly about it, Mr. Chairman.
Maggie, the board, what is your view?
Yeah, we have grave concerns about having evidence automatically excluded based on an interpretation of that, and which is why, typically this goes in front of a judge, and the judge has the ability to exclude evidence at any point in time if he feels like it is prejudiced or was done in bad faith. But now we put language in here that is automatically going to throw it out. And in our opinion, we have to look at cases. Let's say we had somebody who is suspected of murder or child abduction. It is the victims in those cases who are going to be impacted by far the greatest if something gets thrown out for a technical issue.
Yeah, so Senator Stewart, you don't want to do that, is that right?
Mr. Chairman, I think this is actually helpful to the chiefs. I'm not sure.
I agree.
Mrs. DeBoard was following what I was trying to do. I really do believe that amendment is fair and it works for both sides. And it accomplishes the law enforcement's ability to do this after 5, which I know they need to do at times, but it prevents the situation that Steve Benjamin brought up, that officers will all wait until after 5 to get these, because they will have to answer for that after the fact as to why they did it.
Okay.
So I'd move that amendment.
Okay, is there a second?
Second.
Any discussion on the amendment? All in favor of the motion to adopt the amendment, say aye.
Excuse me. Hold on.
Senator, you go
Can you
strike.
just read? I'm following the lines.
Read it carefully. Read it again. Line 105.
Mr. Chairman, on line 105, after the word subsection, which is the 6th word on that line, put when circumstances necessitate.
Okay.
Comma.
In which case, okay.
Comma, in which case, blah, blah, blah.
Okay, everybody got that? If when circumstances necessitate, that's the language on 105. All in favor of that amendment, say aye. Aye, all opposed, no. Motion carries. Okay, Nate Green, you have anything to say on this bill?
Thank you, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, speaking on behalf of the Virginia Association of Commonwealth Attorneys. We do support the bill. We thank the senator for bringing it. I would just ask for this one additional request. I apologize. I know we're getting a lot already. But my understanding of the law at this time is that the change in law would take place March 1st, and this change would take place July 1st. So we've got a couple months there where we've got some confusion. I would ask, and I'm not as good on the legislative enactment clauses as I probably should be, but I would ask for the emergency enactment clause so that it can go into law at the same before the March 1st change in law goes into effect. Thank you.
Emergency clause. Okay. See,
that makes sense.
Okay. Is there a motion to adopt an emergency clause?
So moved.
Okay. Is second, all in favor say aye. Aye. All opposed, no. Okay. Going to effect real quick. All right. John Jones, you have anything to say?
Mr. Chairman, thank you. I want to just reach out and thank Senator Stewart for his work on this in the committee. The Virginia Sheriff's Association supports the substitute as amended.
Okay. All right. Maggie, the board, do you have anything else to say? Maggie?
No, sir. I would
Yeah,
just
yeah.
want to thank Senator Stewart and Senator Servo and others for working with us to make some good changes to this bill. Thank you.
Okay. Is there a motion to adopt the substitute and line amendment? Doesn't have to go to finance, does it?
Move to adopt
Yeah,
and
okay.
refer.
All right, no, it does not have to go to finance. Okay, a motion to adopt the substitute and the line amendments and the emergency clause. All in favor, vote aye. No. I say aye. All in favor, say aye. Okay, is a motion to report the substitute and line amendments, et cetera. All in favor of that, vote aye.
Senator Norman, how do you wish to vote? Ayes 14, no 0.
14-0, the motion carries. The bill is reported. Senator Morse, do you still have one more? Senator Stanley, I can't. Do we get rid of? Have we dealt with Stanley's other two bills?
How come you always use the words "get rid of" when you say my name? What's
Get
wrong
rid
with
of,
you?
yeah.
I've got two quick bills. Senate Bill 1415.
All right, go ahead.
Senate Bill 1415, ladies and gentlemen, Mr. Chairman, members of the committee, comes from VCJC, and this bill is based upon the recommendations of a group of juvenile and domestic relations district court judges. As you know, if you practice law, there are two types of protective orders: child abuse protective orders and family abuse protective orders. As it stands right now under current law, if someone violates a child abuse protective order, then the court must issue a new family abuse protective order, which is kind of not very logical when to have to issue a family abuse protective order when someone violates a child abuse protective order, because they're actually different in their intent and in their application. So what this bill does is it removes any reference to child abuse POs from the family abuse PO statute. Doesn't stop child abuse protective orders, but just removes that interlocking part with the family abuse protective order violation statute. And that way, it allows a judge to no longer be required to issue a family abuse protective order on top of somebody when it violates a child abuse protective order. And it also then also clarifies that the punishment for violation of a child abuse protective order is a class 1 misdemeanor if there's any actual injury. And if the violation involves acts of commission or omission that endanger a child's life, health, normal development, or results in bodily injury to the child. And if there's no injury, Mr. Chairman, members of the committee, then the violation is merely contempt of court for violating the child abuse protective order. That's the bill.
Mr. Chair, I believe there are some technical amendments that need to be moved for the bill too.
All right, okay, technical amendments. What are they?
It's basically just changing some endangers to endanger on line 117, striking a comma on line 18 and then inserting an or. On line 118 after the word health, striking comma or normal development. And on line 118 after development or striking results and inserting result.
Is there a motion to adopt the amendments?
Mr. Chairman.
Yes.
Mr. Chairman, I would move to adopt the amendments except striking the word normal development, because, Mr. Chairman, that is consistent with not only the orders that we have, but also the application of normal development in terms of a judge determining whether there's been abuse of a child. So
okay.
I think all the other technical amendments are fine, but I would leave because normal development has been in the code for a long time. It's understood by legal terms. So,
okay.
and I know that the Supreme Court is a little adverse to that being pulled out right now at this time.
Okay. All in favor? Is there a motion to adopt the amendment as explained by both Steve and by Charles and by Senator Stanley?
Mr. Chairman, I make that motion with my caveat of the restoration of normal development.
Yes. Okay. Second. All in favor of the motion say aye. Aye. All opposed no. The amendment's adopted. Now, is there somebody who would like to speak from the Supreme Court? Sandra? Sandra?
Mr. Chairman, members of the
Committee, Sandra Carrison, Office of the Executive Secretary at the Supreme Court of Virginia. Thank you for the opportunity. The court has no position, and with Senator Stanley's explanation and response to the proposed amendment, I have no further comments, but I'm available to answer any questions. Thank you.
Okay, Valerie, go ahead.
Thank you, Mr. Chair and members of the committee. My concern is with the words normal development, specifically as it relates to the acts of omission and criminalizing that. So normal development could mean a lot of different things in the criminal, and to put it into the criminal context versus just a concern about child welfare just makes me very concerned, and I think it would also lead to increased litigation. Thank you.
I think we took out normal development, right, Senator?
No, I think that Senator Stanley wanted to put that back in.
No, Mr. Chairman. I asked to be left in, and that was what was adopted. That has been a part of our code and was not even a part of this bill, Mr. Chairman. And so had nothing to do with this bill. It seems like we're just trying to clean up the code a little bit. I understand that perhaps the House version may be coming over with that, Mr. Chairman, so I'd ask that my bill be different from this so we can put it in committee and have a good, solid discussion about that. Thank you, Mr. Chairman.
Okay. We have a disagreement on that issue. Chuck Slemp.
Mr. Chairman, members of the committee, I serve as a Commonwealth's attorney for Wise County and City of Norton and am a member of VCJC. And this was a bill that came out of my committee as a co-chair. And so, first of all, I want to say thank you to the senator for carrying it. And just real quickly, I know I respect the committee's time. I want to tell just a couple things. The first that Senator Stanley hit on the head was the confusion about having to have a family protective order when a child protective order is issued. It just doesn't make sense to have a new protective order of a different kind issued. And then our committee also talked about and looked specifically at the language of these protective orders, child abuse protective orders being violated. In theory, someone could have a show cause and a criminal charge for the same action. And so the thought was actually having a criminal charge when there was injury, an omission that resulted in injury. And I'll tell a little bit of a story from my past life as a parents attorney, indigent defense attorney. And that was, I had a client who had a protective order, child in foster care. The child abuse protective order against this woman ordered her to comply and cooperate with DSS. She didn't return DSS's phone call, and she got not only a show cause, but also a criminal charge we had to defend while she was trying to get her child back. It just made no sense. And so VCJC asked you to adopt this, and it comes at the recommendation of both defense attorneys, prosecutors, judges, and folks from all over. Thank you.
So you support the bill. Okay. Anybody else need to say something? Is there the motion to report the bill as amended? Been moved and seconded that to report Senator Stanley's bill as amended, Senate Bill 1415. All in favor vote aye. All opposed vote no.
Senator Norman, how do you wish to vote? Ayes 13, no 0.
Senator Stanley, you still have Senate Bill?
Yes, Mr. Chairman, members of the committee, very quickly. Senate Bill 1426 is a bill that was drafted and was to be offered by the late Senator Ben Chafin. I've agreed to take that on and that responsibility for my good friend. Basically, we have restitution property orders in civil cases and criminal cases. In this 19.2305.1 is restitution in criminal cases. What Senator Chafin's bill sought to do was that right now we have orders of restitution that can be docketed in the name of the Commonwealth, but these can be also docketed now in the name of the victim if the victim requests in writing that the order be docketed in the name of the victim. And then it goes through the process of how then that can be entered and how the court shall docket it. And then and this is on page 8, starting on lines 191 to page 9, ending on line 2012. And so it actually allows a balance for restitution which has been a civil judgment in the past, to be docketed in the name of the Commonwealth or at the victim's request in the name of the victim. And that's the bill, Mr. Chairman, but I do believe there's some amendments that Charles may have.
Okay.
Correct, Mr. Chairman. There's
Okay.
3 technical amendments. The first one is on line 191 after defendant inserts unless an order for restitution is docketed in the name of the victim or it is ordered that an assignment of the judgment to the victim to be docketed. And the other 2 amendments are just correcting some spelling errors in the bill.
Okay. Is there a motion to adopt these amendments, line amendments?
So move.
Second. All in favor say aye. Aye. All opposed, no. Motion carries. Okay. Does the Supreme Court, Christy Wright, have something to say about the bill?
I'm just here and available for questions.
Okay.
We had worked with the proponents of the bill, some circuit court clerks to make sure it was something that we could implement, and we have no position. Thank you.
Okay. Now, Frank Hargrove Jr. Frank Hargrove Jr.
I'm mute right now. There you go.
I appreciate Senator Stanley's attention to this issue. Senate Bill 1426 is good for crime victims. It's good for circuit court clerks' offices, and it's good for criminal defendants. So,
okay, thank you.
Clerk, I support this.
Okay. Anybody else want to say something? Is there a motion? Motion, Senator Stanley? Motion to report
Yes.
as amended?
So move as amended.
To report as amended. All in favor of the motion to report as amended, vote aye. All opposed, no. Vote no.
Senator Norman, how do you wish to vote? Ayes 13, no 0.
13 to 0, the bill is reported. All right, one more bill, and that's Senate Bill 1306, Senator Morse's bill.
Thank you, Mr. Chairman. On the previous bill, 1426, would you please, would the clerk please note me as recording voting aye? Thank you.
Okay. All right, Senator Morse, your last bill is 1306.
Thank you, Mr. Chairman. We've been down this road before. First of all, I want to move the committee substitute.
It's been moved.
They've already been moved.
And is there a substitute? You're moving the substitute? Okay, moving. It's been moved and seconded that the substitute be adopted. All in favor say aye. Aye. All opposed, no. Motion carries. All right, what's the difference?
The first thing, Mr. Chairman, is this bill tightens up language dealing with the diminished capacity of individuals with a physical or mental incapacity. Please look at lines 38 through 44. And it refers to people that are in need of counseling or supervisory assistance, those individuals who have been diagnosed on the autism spectrum, they have a developmental disability or an intellectual disability, and it simply says that a jury or the court may find the accused not guilty of violating this subsection, but guilty of a simple assault or a assault and battery, which is a Class 1 misdemeanor. That's one of the changes. Number two, this bill removes simple assault from the statute dealing with assault and battery on an LEO. Everybody remembers Senator Servill's bill regarding, or antidote regarding throwing an onion ring. But as most people know, an assault is simply a threatened bodily harm. So when I pull back my fist, that is an assault. When I pull back my fist and I make contact, that's an assault and battery. The reason I have changed the language so it has to be an assault and battery is for the additional situation in addition to throwing the onion ring. If an individual pulls back his fist, say he is going to assault an officer, thinks better of it, realizes he's in the wrong and doesn't do that, under the current legislation, he's guilty of an assault on an LEO and faces a Class 6 felony of up to 6 months. The third thing that this bill does is on lines 36, it removes the mandatory minimum sentence of 6 months. We've discussed that again and again and again. This amendment fixes the problem that they raised in the House of Delegates. Let me see, and the last thing that I want to point out is with the Virginia State Police have records from 2019. They recorded 1,939 charges involving law enforcement officers. 1,357 of them, or 70%, involved no injuries. No injuries. Not minor, not major, no injuries. And those people are currently charged with a Class 6 felony and a mandatory 6 months. I'll answer any questions, Mr. Chair.
Any questions of the patron? Yeah, Senator Saslow.
Well, Joe, as you know, you can hit somebody and actually knock them off their feet, but no bruises.
That's a battery.
Which would indicate no injury.
That's a battery.
No bruises under the code, that would constitute an injury.
I said if there were no bruises. But he just knocked off, you know, you hit them, you knocked them back, but there were no visible marks.
It's still a battery because you touched them.
That's an assault and battery, and that would be covered.
That's mandatory.
That's, well, under the current legislation, it is mandatory, but my legislation would take out the mandatory minimum 6 months. But under your scenario, that would include an assault on a law enforcement officer. It would be deemed an assault and battery.
Mr. Chairman?
Senator Obenchain.
Yeah, how about the guy who swings the baseball bat at his head, intends to kill him?
You've
or
I get it.
Intends to hurt him.
Attempted murder.
I get it. And you've raised this example before, and the more appropriate charge would be attempted malicious wounding.
Yeah. Okay.
Mr. Chair.
Yeah, Senator Peterson.
This is sort of more of a mechanics question. If we pass the bill repealing mandatory minimums, wouldn't this become moot, at least the 6 months?
That provision would be.
Okay, that provision would be.
Yes, sir.
Second question. The provision about basically negating mens rea, negating intent because somebody is autistic or in some type of assistive situation, can't that already be factored in by a fact finder? I mean, isn't that already used to negate mens rea or the intent to commit a criminal offense?
If there is no mens rea, there's no offense. This code section would still allow for a conviction for a misdemeanor with diminished capacity, developmental disabilities, et cetera. Those lines 38 through 43 do not address scienter or mens rea.
Okay, I guess.
In other words,
right? I understand. I understand perfectly. I guess my question is, you know, if somebody, and let's use autistic because I'm familiar with that. If somebody's autistic and they lash out and they strike people and they're just more prone to do that than the average person, I understand that may be brought in front of a Commonwealth's attorney who may decide not to charge.
Yes.
And may be brought in front of a judge who may decide not to convict, or a jury that may decide not to convict. I guess I'm just having a hard time wondering how this changes. I understand it only becomes a misdemeanor, but then you're going to sort of open the door to a whole new collateral litigation as to whether or not somebody fits into those categories.
Okay. In the situation that you described, what it would prevent is that individual from being charged with a felony, Class 6 felony. Could be convicted of a Class 1 misdemeanor. Under that situation, though, a defense attorney would have two arguments. One, because of his being on the autism spectrum disorder and he lashed out for whatever reasons, Judge, I'm asking you to find him not guilty. He didn't have the requisite mens rea. Default, Judge, if you do find him guilty of a misdemeanor as opposed to being classified a felon.
Mr. Chairman?
Yes, go ahead.
Stewart. Joe, Senator Morrissey, my concern is this, along the same lines as Senator Peterson in lines 38 through 44. You're aware that we passed a bill 2 years ago which would actually allow the judge to take a case like this under advisement if they were under a developmental disability or on the autistic spectrum.
Absolutely.
Which I carried that bill for 5 or 6 years until it was finally passed into law. This conflicts with that. And so I'm actually concerned that we would be I'm concerned that courts will look at this and go, well, now I've got to, because this is a specific code section.
Mr. Chairman.
We must convict them of a Class 1 misdemeanor versus giving the opportunity for the advisement.
Mr. Chairman.
Let's see, Senator Morrissey wants to answer.
My first reaction is...
Mr. Chairman, I was going to, okay, fine.
Go ahead.
Go ahead, Senator Morrissey. Go ahead. He answered.
Okay. My first reaction is no, that judge still absolutely has the option of doing what your very important legislation did 2 years ago. This does not at all prevent that judge from imposing that disposition. If you look at lines 42, where it says the court may find the accused.
Okay, we got to move along now. There's some people who would like to speak, I believe. Let's hear them. People would like to speak. John Jones? John Jones?
Yes, sir. Good morning, Mr. Chairman and members of the committee. I've been following the discussion, and the Virginia Sheriff's Association is opposed to this bill because it does remove the mandatory minimum of 6 months for assault on a law enforcement officer. Thank you very much.
Wayne Huggins?
Mr. Chairman, thank you very much. We oppose the bill for the same reason that John just mentioned, but at the same time, I'm concerned about the process for bringing the charge of assault. As I understand the senator's bill, an assault and battery has to be investigated by someone other than the officer who was assaulted. We have no problem with that. That's already done. But the problem comes in, it says that the arrest, indictment, or service of a petition in the case of a juvenile shall be approved by the attorney for the Commonwealth. If I'm a state trooper out in the middle of nowhere and I'm assaulted by, let's say, an out-of-state person, by what authority do I hold that person while I'm waiting for an independent investigator to come investigate it? And then by what authority am I holding that person waiting on a decision of the Commonwealth's attorney?
Yeah, let me address that. Yeah.
I don't have any legal authority to hold that person while all of these necessary processes are being done. I have to turn them loose. I've been assaulted and they go down the road. At least that's my reading of the bill. I hope I'm wrong. Thank you.
Yeah.
I'll try to address that, Mr. Chair.
Very briefly.
Respectfully, I do think you're reading it wrong. The officer would still be able to charge the person with a misdemeanor simple assault. That person now is docketed in a court in Hanover County, notwithstanding that the person lives in North Carolina. And then thereafter, after the appropriate investigation, if an enhanced charge was appropriate, it could be effectuated.
Well, it does say the arrest has got to be approved too.
Sorry, John?
It says on line 165, the arrest also has to be approved by the attorney for the Commonwealth. Isn't that right? Anyway, Maggie, the board.
Thank you, Chairman. I represent the Virginia Chiefs of Police. We also oppose the elimination of the mandatory minimums, especially with the lowering of the threshold for felony assault against a law enforcement officer. We are in a very difficult time with being targeted as it is. We don't really oppose the language about the diminished capacity. We understand why that is in there, and we really take no real position against that. But the last language that Wayne Huggins just spoke about is a concern for us. Because you have already, by part of the language in here is fine. You have a check and balance piece in place here that says that independent officer has to look at that charge against assault and do that investigation and then seek that petition or warrant. We don't oppose that. That's a check and balance piece with juveniles that is there obviously because of concern for them. But now taking that to a political entity, elected official, to then even approve whether we can actually proceed with the arrest is unusual, and we think it's overkill in this situation. That same political entity, that Commonwealth attorney, will be responsible for prosecuting that case once a charge is obtained. But you already have a check and balance piece in there by having an independent investigation. Having them approve an arrest just for an assault on LEO is completely unnecessary in our opinion. Okay. Thank you.
Senator, Mr. Chair, yes. I don't want to get short shrift to Wayne Huggins' concern, and I just wanted, he raised a very valid one, but if he'll look at the language, before any arrest, indictment, or service in violation of subsection C. My point was that the person could be charged with a violation of 18.257, let go to a sister state, and then after it is appropriately reviewed, then it could be enhanced to a subsection C violation.
I know that. Okay, how about, Joe, deleting lines 101 to 106? Motion, I'll move the motion to, I move that those lines be taken out of the bill. This has to do with the way you go about doing it. That's the problem.
Mr. Chairman, why are we doing that?
Because of, it's complicated to do this. It's very unusual.
Mr. Chairman?
Yes.
I would just like to point out that that concept was actually promoted by our own Colonel Pike, who indicated during the testimony we took over the summer that he thought one of the problems with this existing regime was that you have officers making charging decisions involving matters where they are the victim, the lead investigator, and the lead witness.
I understand. It goes beyond that, though. Let's hear Teresa Champion. You'd like to say something? I know what time it is. Go ahead. We need to get this over with. Go ahead, Teresa Champion.
Thank you, Mr. Chairman. My name is Teresa Champion with the Virginia Autism Project, and I'm speaking with reference to this bill in the diminished capacity. I think you've heard testimony, and everyone understands that the reality is many people with disabilities do not have purposeful control over their body motions.
Right.
Families live in fear of having to call for help when their loved one is in a crisis because they could be charged with a felony. And if you have a felony on your record, that puts your social services at risk, the very things these families need. Let's put them in between a social service system that doesn't have resources, a medical system that doesn't care for them, and a judicial system that holds them responsible. Thank you.
Thank you. Ashley Shapiro. Very briefly.
Yes, thank you, Mr. Chair. I'm Ashley Shapiro from Justice for Virginia, and we do support this bill. It strikes the balance of keeping an enhanced penalty if an officer is injured in the line of duty, but requires both a battery and an injury. As the statute stands now, it's my experience that it's usually used to cover for police use of force. All too often, an officer charges police assault on a police officer for any slight resistance to the officer's escalation and their use of force. The current mandatory minimum chills the right to a trial for those charged with this offense who are forced to take a plea rather than risk the 6-month mandatory minimum. This also chills the ability to file use of force complaints and the transparency that this legislature has been seeking in the last 2 sessions. Finally, and most importantly, this statute is disproportionately used against people of color. They are more likely to be charged, more likely to be convicted, and more likely to be sentenced under this statute, and therefore we support this bill.
Okay, Eugene Oliver.
Thank you, Mr. Chair. My name is Eugene Oliver. I'm president of the Virginia Association of Criminal Defense Lawyers. We support this bill for the reasons that the patron stated to address one of the issues brought up in terms of how these things are charged. I believe the charging language of having an investigation by an independent officer is essential. I've had specific cases where other officers on scene have said that it was mischarged because the officer who was the victim of the assault was the one who brought out the charge and had a different opinion than independent observers. So I do believe that that check is important. With all that being said, I ask for your support on this bill. Thank you.
Okay, is there anybody else would like to speak on the bill? We need to move it along.
Give me 15 seconds, Mr. Chair, to conclude.
Yeah, go ahead, Senator.
This legislation is going to go through other iterations, but please let's not have somebody who is intellectually disabled in a group home or has some other mental illness who doesn't commit a battery upon a police officer charged with a Class 6 felony. Let's please move this bill along, and I'd ask the body to report it to the full Senate, Mr. Chair. Thank you for your time.
Move to report.
Yeah, move to second to report. I like the part of the bill dealing with the diminished capacity and autism. I do not like the last part of the bill. Just it's too complicated to get the attorney for the Commonwealth. Okay, all in favor of the motion, say aye. No, all in favor, report the substitute by voting aye.
Senator Norman, how do you wish to vote? Ayes 9, noes 5.
Ayes 9, noes 5. The bill is reported. Nothing else to be done. This committee will rise.